Yes,
Thank you, Your Lordship. I beg to mention item number 29 of today's list, my lord. Yesterday, I have filed an additional affidavit. I may be allowed to send a requisition to bring the record to this. Of that, my lord.
I have to simply appear in the same case, my affidavit filed yesterday, it is become record.
Lordship for listing on ISCB in 9/5/2023 for condonation of delay in RSA.
For?
Condonation of delay.
Okay. Condonation of delay for what?
RSA number, filing number 132312/2020.
When did you file it?
23. Already
Why it has not been listed?
it was listed earlier on 2 days.
Then?
So now for listing, now for listing in order.
Hello? Date already before vacation.
For motion item 1,
My lord, in this case, I supposed to file one affidavit, my lord, additional affidavit. I obtained the document from my client, my lord. So some time may be given, my lord, for filing. Injunction was initially allowed, then in.
You have not filed the additional affidavit.
I have obtained the document, my lord. It is the old document. So I will require some time. Only last week they have provided.
Then why you are not filing it?
I am filing, my lord.
How much? After vacation?
Okay.
The counsel appearing on behalf of the petitioner submits that the additional affidavit would not be filed as he have only recently received the documents, taking into account the above. Let's this matter on 18th of July 2025. In the meantime, the additional affidavit will be filed.
so
May I please, Your Lordship? Transfer petition has been filed for transfer of title to divorce from title to divorce number 100 of 2024 from Hojai to Guwahati by the petitioner wife, Your Lordship. Already 2 cases have been filed by the petitioner in Guwahati itself, Your Lordship. So this matter may be transferred from Hojai to Guwahati, Your Lordship.
Why?
She is staying in her elder brother's house. Otherwise, she has no other way to. She is very other livelihood, Your Lordship. Source of income is not there, Your Lordship. Having
When did you leave your husband's house?
on husband's house, Your Lordship. 3/6/2022, Your Lordship. 3/6/2022. She has 2 daughters, Your Lordship. Younger one is with her, Your Lordship, and elder one is with the husband. They didn't allow her to bring the elder one, Your Lordship. And she has no
So
other.
you have not met your elder one for the last 3 years.
She went to meet her, but they didn't allow her, Your Lordship.
So you can therefore go to Hosai.
Yes, Your Lordship.
So therefore you can go to Hosai. Because you have gone to meet her, your elder daughter.
For that purpose, she will go, Your Lordship. Already 2 matters have already been in Guwahati itself, Your Lordship. One is in CJM and other is in Family Court Guwahati, Your Lordship. That's why.
What about you filing a case out there at Hosai? And how are you taking up that matter?
They have filed only, respondent filed that
Huh?
case. The respondent filed that case in Hojai.
That is versus Sandeep Chakraborty.
Yes, Sandeep Chakraborty versus Anita Chakraborty.
So that is who filed?
A respondent filed in Hojai. And she filed in Guwahati.
No, this
For one is for maintenance and
annexure
other is,
1 is who?
Your Lordship.
Annexure 1?
Your Lordship.
Annexure 1.
Annexure 1 is, that is FIR, Your Lordship.
Who filed?
She filed.
No, you filed.
Yes, myself.
You filed.
Yes, because at that time I was there. On that very day, yeah, they threw me out that day.
So thereafter, nothing remains.
No.
You
No,
have
not
never
nothing
been
remains.
there to
She
Hojai?
immediately took help from 181, Your Lordship, and they came and did all the procedures, Your Lordship. And after that, she contacted with her brothers, Your Lordship, and
So there is a proceedings under 125 pending here.
125. She has filed one divorce criminal FC criminal case 216 in 2024 in Guwahati, Your Lordship, in family court, and other is in CJM court.
What is the next date fixed before that
So,
court?
today, Your Lordship. That respondent filed that divorce petition, Your Lordship, that is today only. That is today for put up. Status is for put up, Your Lordship.
You have filed your written statement.
No.
When did you receive the notice?
Notice. Your Lordship, I have the status, Your Lordship, hard copy of status, Your Lordship. I have annexed the petition copy also.
Tell me, what is the next date?
Next day today only,
For what?
put up.
So you have now never appeared before that court.
No, Your not appeared, Your Lordship.
Status?
Yes, Your Lordship.
How did you receive this notice? How did you receive this notice?
That thing I have no knowledge, Your Lordship. I have to ask them, Your
No,
Lordship.
why I am asking,
Yes, Your
you
Lordship.
say that you stay in Guwahati.
Yes, Your Lordship.
The address mentioned in that application for divorce is in Nalbari.
Yes.
How did you receive the notice?
Her parental house is there, Your Lordship. Petitioner's parental house.
So you have no source of income.
No source of income and mentally disturbed also, Your Lordship,
Why?
because lots of this harassment is going on. Because she couldn't meet her elder daughter also.
You should notice making it returnable on 21st of July 2025. Steps be taken by way of registered as well as usual within 3 days. The petitioner is further directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. The case of this is an application filed under section 24 of the Code of Civil Procedure seeking transfer of title suit D number 100/2024 pending before the court of the district and session judge Hojai to the competent court, to the family court at Guwahati. Full stop. The counsel appearing on behalf of the petitioner has drawn the attention of this court that that there is already a proceedings pending. There are already 2 proceedings pending before at Guwahati between the petitioner and the respondent. Full stop. He referred to FC's criminal case number 216/2024 pending before the court of the principal judge family court Kamrup Metro at Guwahati, as well as Miss DV case number 144/2024 pending before the chief judicial magistrate Kamrup Metro at Guwahati. She therefore submitted that not only the petitioner herein have financial resources, but there are two matters pending, two proceedings already pending before the courts at Guwahati, for which the proceedings which have been filed by the respondent before the court of the learned district and session judge Hojai be transferred. Having gone through the materials on record, this court is of the prima facie opinion that the petitioner have been able to make out a case for which this court therefore stays the further proceedings of Title Suit D number 100/2024 pending before the learned court of the district and session judge Hojai Sankardev Nagar till the next date. Effect service by Dusty. Failure, next time if I am sitting, vacate the order.
After 4 weeks,
Specific
at your
date.
lordship convenience.
I have fixed the date.
Yes,
three,
please, your lordship.
Yes, what is this?
Lordship, while filing the MSC claim, 141 days was delayed on the part of the petitioner's claimants. my lord. And the learned tribunal, while dismissing the section 5 limitation petition, observed that the petitioners, those stated
Hey, 111 to কেতিয়া fix করছো? It is last Thursday. No. I fixed it on 22/7. Not 26, 22/7. This matter came up on last Tuesday. Last Tuesday, Liston's auction. Sina, last Tuesday, Liston's item number 4 to 8.
wait, 22/7.
Vale? Issue notice making it returnable on 22/7/2025. To stop. Steps be taken upon the respondent number.
one and two.
1 and 2 by way of registered as well as usual. In addition to that, the petitioner is also directed to effect service upon the respondent numbers 1 and 2 by way of Dusty. Within 3 days, they are going to, by the way of Dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the rejection of the application filed under Section 5 of the Limitation Act for condoning the delay of 141 days in filing of the claim petition by the order dated 6/12/2024, passed in Miss MAC case number 6/2024. Full stop. Taking into account that similar matters are being taken up by this court, list this matter along with CRP numbers 111, CRP IO number 111/2024 on the next date.
Obliged,
Service, Dusty, you complete.
obliged.
Item 4,
Yes, madam.
Yes, Lordship, I've come against the order rejecting my petition, now the order 7.
What are you challenging here?
The order rejecting my petition under order 7 rule 11. And
Order
10
7 rule 11.
Yes, and order 10.
What is
Order
your
1
ground?
and 10. Lordship, I am neither necessary party or a proper party, no prayer against me, nothing against me. Lordship. Only thing, I had awarded the contract to the respondent number 2, and he had subcontracted it to the plaintiff. And now, and the term contract is already over. It's done and dusted up. They made all payments to the.
You're the defendant number 2.
Lordship,
You are the defendant number two.
yes,
Let's see the plaint.
Annexure 1. Annexure 1, page 15.
Suit for recovery.
Yes.
Is a commercial suit.
At that time, yes, actually. In that time, there was no commercial suits, Lordship. So now,
Oh, now it has been, oh, it's a
suit is
suit for,
made in the title suit actually is for recovery of money. Out and out recovery of money.
now being a commercial suit now, obviously it will, by virtue of section 15, it will be there in the commercial court. I think that's the commercial. Court. Now, where is the allegation? You are the defendant number two.
Even the two, there's no, absolutely no, only Lordship in paragraph 7, he makes a statement that he initially, thereafter, the defendant number 1 and the plaintiff met the defendant number 2 and informed that there was no drain in the site. That is one. Defendant number 1 and 2 did not pay any heed. Then Lordship will come. And then again 8, due to the insistence of the defendant.
So you are a subcontractor.
Plaintiff is a
Plaintiff is a subcontractor. So you gave a contract to the defendant number 1. And the defendant number 1 gave you a contract to the
plaintiff.
plaintiff.
I have nothing to do with that. In fact, the contract is also over.
So don't appear. Is he asking for any relief?
No, none against me.
So don't appear. Be happy.
It's not proper not to appear when the court summons. That's why we have appeared.
File an application for striking out.
I thought that was rejected.
Filing an application for striking out has been rejected, or order 7 rule 11 has been.
And order 1 rule 10 also.
Striking out the name. So you are challenging 6/1/2025
Yes, Lordship.
order.
Yes. Okay, go ahead.
This is not an order 7 rule 11.
Lordship?
This is not an order 7 rule 11. You are challenging 6/1/2005.
6/1, 2000.
Page 67.
Yes, Lord. That part is not written that I file an order 7 rule 11, order 10, or 1 rule 10. It's not in the order, it's in the petition, it's there. In my petition, I have written that, page 57.
Level, just issue notice, nothing more than that. No stay.
What do I do?
Don't appear. There's nothing against you. So don't appear. Let it, we'll issue notice. Or should we issue a rule? Admit it and have it after 4 or 5 years. In the meantime, I hope the suit is disposed. Issue notice. I normally don't, I fix a date. I think I don't fix a date, making it,
Whatever, Lord, your
issue
Lordship,
notice, making it returnable by 6 weeks.
whatever. Whatever, it's up to your Lordship.
Steps be taken upon the respondent numbers 1 to 5 by way of registered as well as usual within 7 days. The petitioner herein have assailed the order dated 6/1/2025, whereby passed in title suit 76/2018. Why did you file this so late?
Lordship, I thought it would be over, a small matter.
No. You filed a petition. What is the stage of the suit?
The witness of, evidence of PW has started only.
No. Why did you file this petition in 2023 in a suit of 2018?
That was the instructions we got, Lordship, from the clients.
And why have you approached this court so late? 2 to 7, huh?
Yes. I have come with the time from the,
Hmm?
or from the order, 6/1, I've come in time, on time.
How?
Within 90 days, Lordship.
It's a revision.
Yes, Lordship.
How is the revision maintainable? Because your application and order 7 rule 11, but would it have disposed of the suit? No. Six weeks, steps by registered as well as usual. So the petitioner herein have assailed the order dated 6/1/2025 passed in title suit number 76/2018, whereby the application filed under order 1 rule 10(2) read with order 7 rule 11 for rejection of for striking out and or rejection of the plaint against the defendant number 2 against the petitioner was rejected. Full stop. This court had inquired with the learned senior counsel, Ms. M. Hazurika, as to what is the status of the suit, and it has been informed that the suit is at the stage of plaintiff's evidence. Full stop. Considering the above, though this court has issued notice, this court is not inclined to stay the further proceedings of title suit number 76/2018, pending before the Court of the Civil Judge Senior Division number 3, Kamrup Metro at Guwahati. And this court further observes and directs the learned trial court to proceed with the suit uninfluenced by the pendency of the instant proceedings.
That's my appearance in the trial court.
You don't appear. Who has asked you? Have you filed a written statement? Why did you file a written statement? Nothing is there. So let them go. And one
Why?
fine day you will say, the matter has become infructuous. Yes. Mr. Datta, what is this?
Lordship, here in this civil revision petition, the petitioner is the judgment debtor.
Huh?
Petitioner is the judgment debtor of an execution proceeding, arbitration execution proceeding. So the, why we have come.
Which order you are challenging?
5/2/2024,
Why is it filed so late?
page 29.
Why? Why should we take it up?
Because, my lord, here, the person who appointed the arbitrator, he was interested with the proceeding, he was the party of this proceeding.
Why should we take it up? 5/2/2024 order, why should we entertain it on 2/6/2025? Give me a good reason why. You are asking that the execution proceedings should be stayed, stalled, not executed. Now what has happened in the meantime?
My lord,
After this,
After this, my lord, it has been.
what
warrant
application
of
did you file?
attachment was- I have filed an application that your lordship will find at annexure 3, page 24.
For?
Uh, For
Have you
stating,
challenged the arbitral award on the 34? Then what remains? Hello, which one? Dismiss, withdrawal, which one? Not a case for issue. I'll dismiss it on two grounds. First, without a challenge to the arbitral award, you have no reason. The award is good, and you can't challenge it, taking into account that in view of section 34(3), you have no business. One. Second, 227 jurisdiction is being exercised now in respect to an ongoing execution case of an order of 5/2/2024 on 2/6/2025. So these two grounds. So which one do you want? Morning, one dismissal is done. First, let me start with your case. Which one? Dismissal or withdrawal?
like to withdraw it.
Very good.
Because my lord, but my lord, here, why I am saying, my lord, because. it say
Without a
unholding.
challenge to the arbitral award, Mr. Datta, there is no way out. You should have challenged it. Your basic idea is that the arbitrator was not competent. So that is a ground under 34.
Is there, but my lord, in execution proceeding also.
You
we
cannot
can
challenge
edit
that.
it, my lord.
Because when the act categorically gives a remedy for that, for setting aside, how can you challenge that? And say that, no, this award is there, but without going for that, that award and in terms of 36 becomes a decree.
It's an.
Which one? No, spoiled. Dismissal. Dismissal is 11.5. Withdrawal is 11.1.
Withdrawal.
And let counsel appearing on behalf of the petitioner submits. The petitioner would be well advised not to press the instant petition. Accordingly, the petition stands closed on entry.
6.
Yes,
Right.
what are you challenging?
My lord, page, my lord, 41, my lord. Order dated, my lord, 7/3/25,
Condonation of delay
my lord.
in filing what?
My lord, they filed, my lord, petition, my lord, under order 907, my lord. That could
Huh?
not file, that could not file in due time, my lord.
Order 9 Rule 7 you have filed and you file a section 5 there.
My lord,
Who has given you the best idea on this?
my lord, they filed, my lord.
Huh? Where is the
Subsequently, my
provision?
lord, it was dismissed, my lord. And subsequently, my lord, the petition order 9 Rule 7 was.
What is the position of the suit now?
My lord, last month, this suit was fixed for, my lord, ADR, my lord. It was fixed on, my lord, 4/6, my lord. For, my lord, for, my lord, hearing under section 89.
Bring it to alternative dispute resolution.
Issues.
Okay, where's your application under order 7 Rule 9?
My lord.
Order 9 Rule 7.
At page, my lord, at page, my lord,
On
30.
receiving the summons of the
Correct,
court,
sir, my lord.
the petitioner appeared before the court on demand by engaging on a file. Paid for relied upon documents here, but the employee of the petitioner failed to collect the necessary document due to the union. Absence of the so-and-so was neither willful nor intentional, but there is no prejudice has been caused if the aforesaid order it is set aside against the referendum number 3 and allowed them to contest on it by furnishing them the written statement and not filed the written statement within the. So the filing of the written statement was on 4/6/2024.
My lord.
So you are actually asking for recalling of that order
Yes, my lord.
by
Well,
filing this petition.
My lord, actually, no adverse order has been passed against me, as my lord. No adverse, though my lord, we did not file, my lord, WS in time. but
When did
no-
you file this?
We filed it, my lord, on, we filed it, my lord, on 24/9, my lord.
24/9. And where is that order?
That order. is
24/6, where 6/3, na?
My lord.
Four six. Where is 4/6? In petition filed with defendant number 1, 2, 5, informed that they will come. Who are you?
My lord, I am
With
the
respect to the suit?
defendant number 3 at 6, my lord.
Are you sure to contest the suit?
My lord,
You're sure to contest?
yes, my lord.
You want to contest? Will permit, subject to payment of 35,000 as cost.
Hi, my lord. So,
No, I'm giving you therefore the time. So I'm fixing it in the next date within this month. And then I will permit you, subject to in the meantime, these 10-15 days, go everywhere and collect the 35,000. Issue notice making it returnable on 24/6/2025. Next date,
next date, my lord,
trial court, next date. Have you not mentioned? Because the order was passed on 7/3/2025. You filed this petition when?
32.
29/5. So in the meantime, many dates have gone. Have you mentioned it anything in your petition? Why have you come so late? No, nothing.
My lord, next date is, my lord, 21/7.
Oh, fantastic. I don't need to stay it also. You should notice making it returnable on 24/6/2025. Steps be taken upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. In addition to that, the petitioner is also directed to take steps upon the said respondents by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein is aggrieved by the order dated 7/3/2025 passed in Mize case number 134/2024, whereby the application filed under section 5 of the Limitation Act for condonation of delay of 110 days in filing an application under order 907 was rejected. Pustab. The learned counsel appearing on behalf of the petitioner submits that though the petitioner had filed on mistaken advice an application under order section 5 of the Limitation Act 1963 for condoning the delay, but the reasons were assigned in the application under order 9 rule 7 being a good cause, comma, but as there is no period of limitation prescribed, comma, such an application could have been that an application under order 9 rule 7 could have been filed at any time in the suit. Pusto. The learned counsel further submitted that if the cause shown is a good cause, comma, the learned the settled principles of law stipulate that the suit would be relegated to the date on which the court proceeded ex parte against the petitioner. He therefore submitted that this is a fit case where there is a requirement of interference by this court in exercise of its supervisory jurisdiction. This court inquired with the learned counsel appearing on behalf of the petitioner as to when is the next date fixed in the suit. He submitted that the suit is fixed for consideration in terms with section 89 of the code on 21/7/2025. First, in that view, as the notice has been issued within the prior to the next date, so fixed in the suit, comma, it is the opinion of this court that there is no requirement of stay. First.
Seven.
Get your 35,000 ready, 25,000.
My lord, estimate this was today, my lord.
Huh?
My lord, I am ready to pay 25,000.
I can't today. He will go and spend 40,000 and go into the Supreme Court and get it set aside. Then you may have to pay more money. So 25,000 is good. Keep it ready for the next.
My lord,
You need to pay on 21/7, but you affect the service.
Item 7.
Yes, Mr. Ghosh, what are you challenging?
Page 90,
Page?
90. Preliminary issue of res judicata has been framed, my lord.
Wherein Learned Counsel were paid to file a preliminary issue regarding maintainability of the student. That pleaded with the suit in connection to the present court was always over previous year. Separate sheet. And take it.
My contention is that all the issue is to be decided, including the res judicata, my lord. Because it is a mixed question of fact and law, my lord. I want to just rely on judgment 2022.
But why the court is not fixing for hearing on the preliminary issue?
On straightway pass the order, my lord.
No, whatever may be. The court has gone to the question of plaintiff evidence.
Yes.
Are you not the plaintiff?
I am the plaintiff. Plaintiff evidence with respect to preliminary issue.
Why do you say so?
Because the order is, the application has been filed. Kindly see the application.
No. The order does not say that so and so for plaintiff evidence for preliminary issue.
But no issue has yet been framed, my lord. Only this issue has
One
been
preliminary issue in the inquiry is framed in the separate sheet. Where is the separate sheet?
that I have not obtained.
And how is the petition
My lord,
maintainable?
kindly see before that application has been filed, my lord, by them. Page 85.
Yes.
Seeking order to frame a preliminary issue regarding maintainability of the instant title suit.
Hmm.
This application was allowed by this order.
So, argue. Why you are arguing here?
Preliminary issue, on the basis of preliminary issue, the plaintiff evidence is to be given, my lord.
So you say that without the other issues being framed,
Yes.
there cannot be a direction for
Direct-
plaintiff evidence. Well, we can clarify that.
That all,
Finish.
this res judicata issue may be decided along with other issues.
Why should I say so? That you argue that
Well, kindly say one
No,
more
no.
point, my lord.
for that you need to go to Supreme Court. I will only say that there cannot be a plaintiff evidence without the issues being framed. And as such, this court, without interfering with the order dated so and so, will direct the learned trial court to frame other issues and thereafter fix it for plaintiff.
Yes. Then entire,
Then you know what to do. Mr. Ghosh is too expert in that.
my lord, kindly one judgment I'm saying,
Not-
my lord.
Not necessary.
My lord, on that point, my lord, on the ground of preliminary issue, the Honorable High Court remanded the matter to the trial court. Then it was set aside by the Supreme Court, says that no, all the issue is to be decided analogous. Can you see?
What am I saying? Am I saying that no, you don't frame it? No,
No.
I will only say that they cannot be fixing the suit for plaintiff evidence without framing the issues.
All the issues.
Issues. Once they frame issues, then only they can proceed. Then you show this judgment there. Heard Mr. S.K. Ghosh, the learned counsel, appearing on behalf of the petitioner. Full stop. Petitioner or petitioners? Petitioner,
Yes,
comma.
Your Honor.
The supervisory jurisdiction of this court has been invoked, challenging the order dated 16/5/2025, passed by the learned court of the Civil Judge Senior Division Sribhumi, whereby the learned, for short, the learned trial court. Learned trial court had framed a preliminary issue on the question of res judicata, and thereupon fixed the suit for plaintiff evidence. The learned counsel, appearing on behalf of the petitioner, has submitted that the question of fixing the suit for plaintiff evidence does not arise without all the issues being framed. And in that regard, referred to the judgment of the Supreme Court in the case of
2022, 7 SCC, 644,
name.
name Chetranath and others, Hemant Gupta versus Chetranath.
It will luckily reported in so and so. Wherein the learned counsel submitted that the Supreme Court in the said judgment had categorically observed that all the issues are required to be framed, be it preliminary issues or the main issues in the suit. Full stop. This court, this court, taking into account the limited scope in which the instant proceedings have been filed, takes up the instant proceedings for disposal at this stage. Full stop. The impugn order, dated 16/5/2025, it is seen that the learned trial court had framed a preliminary issue on the question of res judicata and further directed the plaintiff filing, further fixed for plaintiff's evidence. First, it being a settled principle of law that the preliminary issues have to be decided only on the basis of the facts, or only on the basis of the averments contained in the plaint and nothing more. The question of directing for plaintiff evidence does not arise. First, apart from that, directing the plaintiff to adduce his evidence would only arise when the issues are framed. First, considering the above, this court, without interfering with the order dated 16/5/2025, directs the learned trial court, that is the court of the Civil Judge Senior Division Sribhumi, to frame the other issues of the suit and thereupon fix the said suit for plaintiff evidence. First, it is, however, observed that in the circumstance, the learned trial court is of the opinion that to first decide the preliminary issue, I think this will be done to frame all the issues
Right.
and before proceeding for the plaintiff's evidence. I think this is okay. With the above, the instant petition stands disposed.
Item 8.
Yes, what is this?
Please,
What are you challenging?
Lordship, a petition was filed under Order 21 Rule 99.
Huh?
was filed under Order 21 Rule 99,
Dismissed,
dismissed.
then
uh, dismissed, and thereafter the consequential orders were passed with respect to police help and assistance, and writ of summons were also issued. All by the order dated 6/5/2025, the petition under Order 21 Rule 99 was dismissed. Thereafter, by order dated 8/5/2025, the police assistance was given. Thereafter, 23/5/2025, writs were issued in respect to the proceeding. What has happened, my lord, in this case, we were not party in the earlier suit. Earlier suit, my
that is
lord,
why you file order 21.
Yes. my lord, there is a judgment and decree passed in RSA number 264/2013 by this honorable court.
Hmm.
And in terms with the judgment and decree 30/7/2024, the decree sought to be executed. But when we came to know, initially there was a report, initially the suit was execution proceeding was fixed for report. And when the civil Nazir went to the place of the
Just
suit,
tell me what you want now.
now
What are you challenging?
the order, because your honor,
Which order?
order dated 6/5.
6/5, it's a decree.
I have a submission to that aspect. Your
What if?
Your Honor, first of all, the petition under the, in the executing court was filed under Order 21 Rule 99, although we are yet to be dispossessed. But having filed a petition under Order 21 Rule 99 also, the executing court's observation in the last of the paragraph is that the petition is hereby dismissed and petition of the petitioner is dismissed under Order 97 and then 29. My respectful submission is that it is not a decree because adjudication has to be done under 98, read with 101. All determination has to be done. To be a decree under 103, there has to be an order for after adjudication. Because 101, my application was under Order 21 Rule 99. So there has to be an adjudication under 100 to have to be treated as a
What
decree.
adjudication do you want?
Because you know, subject to 101.
If a application is filed, bogus application is filed, then the court will dispose of.
Yes,
If you see the judgment in the case of Silver
Yes.
Line, even Brahmo Chaudhary it categorically says that there has to be some prima facie case. You have to come up with some case to that effect.
you know,
Then
our case was that
appeal.
we were not party to the proceeding, Your Honor. And
That is why you file order
Yes.
21 then.
Your Honor, but 97, Your Honor, if at all it is taken as 97 also, if at all take it as a 99 also, it has to be an order after adjudication under 100 or 98 too. And that will be
What do you
subject,
want? Dismiss.
no, Your Honor,
Go to Supreme Court. Thank you.
Your Honor,
I
we
have
may be
made
given a
I've
chance.
tried to make you understand, you don't understand, then go. Where is that order?
Your Honor, order dated 113. Page number 113. Your Honor, we may be given a chance to adjudicate all these aspects before the learned trial court.
Where is that
Because-
order?
Page 113,
15.
113, 113.
Really? You put it on a unlucky number.
All I am praying is that we may be given a chance to agitate all these issues before the learned by filing appropriate application.
Where?
because Before the learned executive
No,
court.
you file an appeal. You get whatever, get a remand from there.
Because you know,
In view of the above, the petition is dismissed, so matter is a decree. Therefore,
but with all respect,
29 is 97, order 21 rule, the petition filed under order 21 rule 97 is dismissed. The moment it is the dismiss, it is the 103. Over, matter.
but my lord, but there has to be an adjudication.
Which one do you want? Withdraw with dismiss?
But there has to be adjudication under 98 too, with all respect, Your Honor, my lord.
Go argue before the appellate court. I don't know, why
But-
should this exercise 227 here?
Police assistance and the case is fixed for your, my lord, on
You
11.
know what to do. It was filed on 8/6/5. You still have time. Go file 1 month appeal. 227, why should I exercise? Well, the Supreme Court categorically observes that when the CPC provides a due procedure, why should I exercise 227?
My lord, the learned
Okay, 11/21/22.
My lord, the under executing.
Withdrawal is 23, dismissal is 30. Which one do you? 1 minute for you to make your submission.
My lord, my reciprocal submission would be before this honorable board is there.
Mr.
It's not under 98. The adjudication,
I'm not going to this. Mr. NBP Sinha, the learned counsel appearing on behalf of the petitioner. First, the supervisory jurisdiction of the court under Article 227 have been invoked, challenging the order dated 6/5/2025, passed in petition number 51/2025, whereby an application filed under Order 21, Rule 97 have been rejected. It is a settled, it is seen from a perusal of the provision of Order 21, Rule 103, that an order passed in a petition under Order 21, Rule 97 of the Code amounts to a decree. First, in that view of the matter, an appeal lies under Section 96 of the Code of Civil Procedure. First, the Supreme Court in the case of Bombay judgment had categorically observed that the jurisdiction under Article 227 of the Constitution should not be invoked when there is an appellate remedy provided under the code. First, taking into account the above, the instant petition is not entertained, for which the instant petition stands dismissed. Be that as it may, taking into account that the instant petition has been filed, be that as it may, this court grants liberty to the appellant and the petitioners to file application under an appeal under Section 96 against the order dated, read with Order 41, in the before the appropriate court, appellate court, against the order dated 6/5/2025, and the period from 2/6/2025 till date be excluded while computing the period of limitation.
Item 9.
Virat, Bombay, Mumbai, কিবা এটা আছে নহয়? 2019 or 1905. Yes, what are you challenging?
the order dated 4/10/2024, which is at page 67, my lord.
Page
67.
67.
My lord, I have prepared an appeal initially before this honorable court. Subsequently, that was transferred to the learned district judge Tinsukia. And while the said appeal has been pending, I have filed an application under Order 1 Rule 10(2) for impleading one of the person who was left to be impleaded in the appeal.
What petition did you file?
My petition is that, my lord,
By the appellant, the
51,
instant
my
appeal has come up before this court on transfer from the High Court in. Yes, what are you challenging? Such a long order, what is wrong with this? That is,
my lord, operative portion is at, my lord,
court have given a careful
73.
consideration to the entire meeting now. So, died?
One of the original plaintiff died after the passing of the decree. Thereafter, I prepared the appeal, and when the appeal was prepared, at the relevant time, original plaintiff was died.
So the original plaintiff died after the decree,
After that,
but before filing the appeal.
before filing that.
So you filed against the dead person.
No, ma'am. I have filed the appeal, impeding the legal heirs
Ah.
of the deceased.
Ah.
I have impeded two sons. One has been left to be impeded.
Huh?
One person, that is the wife of the deceased plaintiff, was left to be impeded as respondent.
Was
In-
left out.
Left out.
So you filed an order 1 Rule 10.
Yeah, I have filed an application under, before this honorable court as IA, my lord. Along with the main appeal as well as the IA has been transferred to the learned district judge. And thereafter, I was.
So therefore, let us be more simple. You filed a decree was passed against you, wherein the plaintiff died after the decree, but before filing the appeal. So by applying 146, you filed an appeal making two sons a party against two sons of the plaintiff. But inadvertently, you left out the wife.
Yes.
Wife. And when you left out the wife, so you filed an order 1 Rule 10. This application was rejected, for which you are here.
Basically, my lord, the ground for rejection of my petition is such.
No, I'm asking you, is this the facts?
Yes, yes.
So the application under order 1 Rule 10 was dismissed, for which you are here. Is it?
Yes, yes. This is.
Let us see your application. But the order is too complicated.
Right.
What is wrong with these judges writing such a long order? What is the name of the great judge? Additional District Judge number 2, 3, here.
Page 73 of the include order. the
Where's your
operating
application?
part. My application is at page 51, my lord.
Page
51,
60.
51.
You filed this petition where?
And initially, before this honorable court, and thereafter, when the matter has been transferred to learned district judge, I was suggested to file a fresh application. That is why this application.
Where have you written it? Where is your IA?
IA is, my lord, page 43, my lord. Page 43 is the IA.
And what is this quoted portion?
My lord, what I have stated in IA, my lord.
Mentioned by passing an order in treatment or responding to made without the collection of the address of the court reflected in So this was a petition in before the High Court.
Yes, my lord.
Why couldn't you write a similar petition there and
I have made-
unnecessarily
I have-
putting these grounds or that grounds?
No, no.
Why are you mentioning these grounds?
No, not ground.
Page 52,
Page 52.
that
is
the
not-
grounds taken and submission in the aforesaid IA for impleading are under. What is this bold letter?
My lord, so for the.
So you have quoted
Quoted, my lord. The-
quoted the earlier petition.
Yes, my lord, stated.
And what has happened now? This was up to 25/10/2024.
Right.
Order 410.
14.
Why are you challenging now?
Because, my lord, my said application has been rejected basically on the ground of my petition was barred by limitation.
Forget about that. I am asking you now why you are challenging. Yeah.
Because the Lapisa, who is the wife of the deceased plaintiff, the
Huh.
necessary party to my appeal, my lord.
Huh?
Because necessary party to my appeal, my lord. Because I have filed the appeal.
Mr. Counsel, I'm asking you, why have you filed this order challenging an order of October 2024 in this court on 31/5/2025?
The petitioner's brother who was severely ill under, followed by the operation on the that is when he,
Now, what is the present status of the appeal?
at the stage of, there is a date fixed for argument.
Ah. Where is that order? It is fixed for argument. Because if the appeal has already been disposed of,
As of now, my lord, I
how
have,
do I know? Because you are moving an
Yes.
application after such a long time.
no, my lord, that's true, my lord. I have approached the
You-
judicial for after a long time.
No,
But
and
so
where have
far-
you explained?
Yes, sir.
You have to give a
Yes,
proper
12, my lord.
explanation. Where?
Paragraph 12
Ah.
of my petition.
Yes.
I have also annexed the medical documents why I could not find, because my mother is the mother,
What is the stage of the suit? Appeal.
appeal.
Where have you mentioned?
That is not mentioned.
Then why should we entertain
My
this
lord,
type?
so far, my lord,
Let the arguments be completed. Hearing judgment be given,
my lord, that's true.
then we'll take it up. I'm here
My lord,
to
that's
take
true.
up the second appeal.
No, for the, my lord, that's true.
Huh?
And so far, my lord, implement of the Gulati size. Whatever, my lord, sees, my lord, the class one years, this is plenty. my lord. I have filed the application in time before this honorable court, my lord. That was
No,
the-
no, first of all, you having filed on 31/5, why should I entertain when you have been such a delay? You see,
my lord,
I'm very strict on one thing. 227, if you are doing it, first of all, 227 is not a right.
my lord,
Absolutely not. 115, there is some right on error of jurisdiction. This court would obviously exercise its jurisdiction under 227 when it sees something is grossly wrong. But you have to approach this court at the earliest.
yes, my lord.
So if you don't approach this court and you approach this court after 9 months, or the 5 and another 2, 7 months, then you have to give good explanation why this has happened.
I have,
There's
my lord,
nothing out there.
what happened, my lord?
I can't.
Only 3 persons are there. The petitioner is the lady, man. She has to maintain her mother as well as the brother. Both are struggling for life. She could not come from Tinsukia to Guwahati.
Then how did you file it now?
My lord, when she has come to my lord name care for treatment of his brother, meanwhile she came. That is.
Huh?
I have annexed the medical documents.
When did he come?
I have mentioned in paragraph 12, my lord, specifically why she could not come at the earliest.
Where is the name care document?
My lord, page, my lord, starts from my lord, page 74, my lord. After recheck, my lord. I have
He
annexed-
came in Health City Hospital in Guwahati on 23/2025.
my lord,
Why couldn't he file it then?
my lord, that-
See?
at that
Page 74.
at that relevant time, her brother's mother health condition is too severe.
So
As stated by her.
then why did he file now?
My lord, after my lord, what happened, my lord?
Brother
after-
is improved.
my lord, a kidney problem, my lord, that will take some time, my lord.
Then?
Still, my lord. That
No
will take some
ground.
time. Thereafter, my still, my lord, he is under medical treatment.
Then
Last, my lord, last.
here, this person's concerned have been continuously, there are various reports
Yes,
in
yes,
Apollo Clinic on 8/3.
my lord.
Then also it has nothing been done.
Yes,
Then
my-
no
my lord,
ground.
whatever. See the lady, my lord, only the. see the
You go
only
and
person-
show that judgment of the Supreme Court and proceed with that appeal. That judgment in Shiv Sankara. Show that and proceed. Because for the plaintiff, there are already 2 persons is already there.
Yeah,
So there, go ahead.
no doubt.
Not necessary to stop this.
What happened, my
Shiv
lord?
Sankara, 2023. Shiv Sankara. So that proceed with that appeal, no case.
Notable appeal will proceed, my lord, then my lord, in presence of these two persons. Not
No,
so
no,
for
no,
the
no,
other
no.
parties concerned.
You go and argue there, show that judgment, because it is not required. When the estate of the plaintiff is substantially represented. Because the person died when? After the decree.
After the decree.
So it was more of a case of an order 1 rule 10. You have a good, very good case, but why should I exercise jurisdiction?
Well, my petition was wrongly rejected, my, that is why.
Hmm.
Well, because no limitation.
No,
my lord.
if it was rejected in October 2024, why should I exercise?
But so far, my lord, delay part is concerned, I have explained, my lord.
No,
What?
I am not satisfied.
And so far, my lord, only lady person, that is why, my lord, she could not come.
I may at best issue a notice and make it specifically clear that the pendency of the instant proceeding shall not be a bar on the part of the court to proceed and dispose of the appeal before the notice. And this is also a similar case like Miss M. Hazarika, where I have issued notice making it returnable 6 weeks
If that being
and
so, my lord,
steps be
if the-
taken after 7 days.
If the appeal is not disposed of during the pendency of this.
Then you come in second
purpose of
appeal.
Approaching this. will be-
I am not going to do it. Or I allow you subject to payment of a cost, 25,000.
My lord, she cannot pay. Already, my lord, she has already experienced for the life of our mother as well as the.
Forget about it. Which one do you want? I'm not going to exercise this type of duty. Sorry. This delay, I am not going to come.
Bench of justice, my lord, nothing more.
Okay, issue notice making it returnable by 6 weeks. Steps be taken by way of registered as well as usual. So the petitioner herein have assailed the order dated
4/10/2024.
4/10/2024, whereby an application filed under order 1 rule 10 of the code of civil procedure 1908 was rejected by the learned court of the additional district judge number 2 Tinsukia on the ground that the said application have been dismissed on the ground that the said application was dismissed as being filed beyond the was filed beyond the period of limitation. Full stop. However, be that as it may, it is seen that the order dated 4/10/2024 have been assailed before this court by filing the present petition on 31/5/2025. The learned counsel submitted that there was a delay in filing the proceedings on the ground that there was that the brother of the petitioner,
Mother and brother both.
mother and the brother of the petitioner were ailing and as such could not file the petition. So this court inquired with the learned counsel appearing on behalf of the petitioner as to how the petitioner now could file the petition if their brother and mother is still ailing. He submitted that he could file the petition as he had come to Guwahati for the checkup of their mother and brother. Be that as it may, the documents, however, show that the mother and the documents, however, show that the petitioner came to Guwahati on 8/3/2025. That says explanation, therefore, this court does not find their explanation to be good, for which this court is not inclined to pass any interim order.
Obliged.
Item 10,
You file an additional appeal.
File.
Give better reasons why you have it. I'll have it next. But I'm making it clear to all the lawyers, if you don't explain, I'm not going to pass any more. You cannot get rid of this. Why you could not, you have given that reason, but what has happened in the meantime? How the proceedings of the suit had progressed, appeal had progressed. Because you, after approaching this court after 7 months, not under. Because 2 to 7, one has to understand that you have to come at the most
Understood.
urgent nature. Then only this court will interfere, not after 7 or 10 months a year. What is left? These appeals are actually to be disposed of within 5 months. And you approach this court after 7 months.
The documents what they have supplied, but I have not found this.
Huh?
I'll update.
Okay, list the matter on so and so.
Let
next
me
week.
fix my name. Sorry.
In the meantime, petitioner is given the liberty to file an additional affidavit.
Meanwhile, madam, I may also be, madam, serve the copy by those two.
Huh?
Serve the copy to the respondent by those two. Sir. So for notice is.
I'm not issuing notice till now. How can you serve?
Fine, sorry. Obliged.
Item 10.
Please, your lordship may kindly pass over for time being, your lordship. My senior is on leave in other section.
We taken up as the last item of the day.
Your lordship.
Supplementary item 38.
Yes.
Well, this is regarding.
You see the judgment? I
Yes,
referred to 98.3.
Yes, my lord, there is a two option, my lord, the either side, my lord, on the case of the date of the judgment decree holder also, and the judgment debtor. They can issue, my lord, initiate a fresh, my lord, by implementing the all such.
No, what we do is, we say disorder. I don't interfere with disorder, but direct the court to take note of that, and you submit the list of legal representatives. And on the basis, the court will give the opportunity to the decree holder to implead. And if it is not there, then I quote that paragraph where the Supreme Court says
Yes.
that if he does not implead, opportunity being granted, then although it would not abate, but can be dismissed for default.
Default, yes.
I think that is the fair way, and thereby you get your chance.
Yes, madam. That I not, my lord.
Where's the judgment?
Judgment
93
was
SCC.
Judgment to.
Because Mr.
my
Mohanto,
own
one
way.
has to understand, the main problem which arises is, hidna mein aata judgment case aata 98 SCC aata kama to likhe chilo.
Judgment, I am giving my lord copies, my lord.
You give it to, I'll just
But
rise
judgment
and
is
come back.
included.
You ask him to give it to you, he'll take it out, because I'll put that paragraph out there. Because nowadays you see there is a constant pressure upon the executing court in view of the judgment of the Supreme Court.
Yes, yes.
So therefore they have also to do. And me, if I issue a notice and stay this, makes no sense.
Done, my lord.
So
But
the best option is giving you the liberty, directing you to submit the names, and the court shall act in terms with that paragraph,
Yes.
and then proceed.
But
But then-
then notice have to go to my lord, first, like the degree.
Notice won't go. Notice you are there. You are going to submit.
I am only one, my lord. The others are saying in different places, my lord. Others are saying in different places. I am the one, my lord. The only four, my lord, person has been substituted. Wife and the three sons.
When was the decree passed?
That was, my lord, initially that was, my lord, in 2013. That was when appeal, first appeal, then my lord, second appeal. Then second appeal came on, my lord, November 2024, my lord. So after that, again, the execution proceeding, that was.
No notice business. The court knows how to do it.
Yes, my
No notice business. They
But-
will implead and
What
then.
my lord, minimum, my lord, that's it.
No, no, Mr. Mohanto, now you have already got your chance. What
Yes,
you need
I
to do.
got this.
I am not going to go into the
I got
question
it,
of
my lord.
notice, because the moment I go into the question, you will be delaying the suit. I know that. I'm just coming, just take it.
My lord. My lord, this is in page number 4. The last para from bottom, my lord, is the fourth line.
Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner. Petitioner herein have assailed the order dated 16/5/2025 passed by the learned court of the Munsif number 1 Nagaon in Mizze case number 65/2025 arising out of title execution case number 6/2013, whereby the application filed under Section 47 of the Code of Civil Procedure, read with Section 151, raising objection to the executability of the decree dated 25/7/2011, passed in connection with title suit number 106/2006, was rejected, comma. This court takes up the instant petition, instant application for disposal at the motion stage. Full stop. Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is the legal heir of the judgment debtor number,
Number 1, my lord, Hemendra Das.
judgment debtor number 1, who expired on 13/3/2015. Full stop. Upon his death, upon the death of the judgment debtor number 1, Hemendra Das, comma, he was substituted in
Last,
no, you said during the period
second appeal. my lord.
of execution proceeding, the deceased judgment debtor was alive. When did he die?
During the pendency of the second appeal. my
When was the second appeal disposed?
lord. That was disposed on, my lord, 22/11/2024.
Where is that? Judgment?
Judgment I have not annexed, my lord, but.
Where is it? How do I know? You
but-
don't
but I
mention
have, my
anywhere.
lord, mentioned, my lord, in my paragraph, my lord. Numbers.
The learned counsel submitted that the judgment debtor, Hemendra Das, died on 13/3/2015, leaving behind the petitioner as well as one Sopon Das and Jitumoni Das, who were
Sons, my lord,
the sons
sons and the wife,
of the,
and wife also, my lord. Sinu Das.
Hmm?
Wife Sinu Das, my lord.
where is that name?
It is para number 5, my lord. It is last.
You said paragraph number 1, leaving behind only 2. See, page 18. Para 1.
There is a mistake, my lord. This actually, my lord, the wife and 3 sons, my
So
lord.
you have tried to mislead the trial court.
That is on part of the mistake of the advocate, my lord.
How can you say that an
But I am
advocate?
coming to 2 facts, my lord.
How do I know? First of all, you don't enclose that RSA. On this ground, I should dismiss your petition. Withdraw, file a fresh one.
My lord,
This type of cases,
My lord,
I-
Just the
Otherwise, I
second
dismiss
of
it.
my lord, I will produce my lord.
No, why on earth? Mr. Mohanto, your specific submission or case is that in the RSA they were substituted.
Yes, my lord.
Then why on earth have you not enclosed the judgment in the RSA?
That was right.
Why? Is it for the purpose that this court would have no other way but to call for the records?
I can, my lord, add to my lord, I'll bring this, my lord, the online copy, my lord, this. lordship.
Last item of the day again. Can't help it.
Okay, my lord, I'll
You
bring.
can't help it. And if
I'll
it doesn't
bring.
reach, I can't help it.
I'll
But this is not, Mr. Mohanto, this is not a conduct which is expressed. I tell you, this is not what. One has to be more clear when you are moving a 227. Don't you think? This is an supervisory jurisdiction which is more of an equitable jurisdiction. Then why on earth have you, your basis is this. You should have categorically said who are the persons. Who are the persons? Where is it?
But in para number 5, my lord, I have specifically mentioned.
No, para number 5. Why on earth have you stated only in para number 5? Who are the persons and what are their addresses?
In the, my lord, the RSA
Where?
judgment, my lord, that was reflected that every time of the event, they were substituted. my lord.
You file an affidavit. I'll take it up next week. File an affidavit, bring or if you want this week, I can have it. Monday, I can have it. You file an affidavit, bringing on record those the RSA judgment as well as also the names of the legal heirs along with their addresses. Monday, you can do it. Today is Friday.
My lord, on, that will be taken on Wednesday, my lord.
This is the matter on Wednesday. On which state the petitioner shall file, by which state the petitioner shall file an affidavit bringing on record the judgment in the case of the judgment and order dated 22/11/2024 passed in RSA number 185/2013. Additionally, the petitioner shall also provide the names of the other legal representatives on affidavit of the judgment debtor number 1 along with their addresses.
Madam.
39,
May please, your lordship. My lord, we have challenged the order that is page 24, my lord. At first, my lord, I want to disclose the petition is not annexed because at that time it was not brought, but it is mentioned here. If your lordship kindly consider this, due to urgency, it was filed page 24. Petition was filed for adducing the evidence of official witness because the original copy of the cell deed has been lost. The attached witnesses have died. So we wanted that official witnesses should come. But that was earlier allowed, but later on rejected.
So, don't you think
Only
without
limited
the,
prayer, my lord.
no,
only-
without the petition as well as any written objection filed, how they will this court adjudicate the order dated 10/1/2025? Tell me. Give me a good idea.
Order is here, my lord, simple.
No,
matter.
how? What is your stand taken in your petition? And what is the stand taken by the respondents? And without that, how
Yes,
can this
that-
court do that?
And it just have been sent later on. So
So you
your
file
lord-
additional affidavit. And also, in the additional affidavit, give the up-to-date status of the suit. Because this is an order passed on 10/1/2025. And you are challenging in the month of May. And why you could not file in the meantime? When is it?
But statements should be there without condemnation petition, statements.
Huh?
Through statements, we will go on.
No, I don't require condonation. Just an
Public.
explanation why you have filed it so late and what is the status of the suit. Means what has happened in the meantime? Because you are challenging an order of 10/1/2025. We are taking up in the month of June. We don't know why, because it was fixed for
Defendants witness.
defendant witness. How far it has gone?
Defendants have taken adjournment that I have no.
So
I have-
this, if you have, produce the certificate, order sheet. You can get it in the e-court also. Just take it out in the e-court website.
Let it come on Friday, my lord.
Right. List the matter
Next Friday.
on 13th. 13th?
Right, Friday, June, next Friday, I mean,
Huh? 13th. When is it, no?
13th June.
This the matter on 13/6/2025. In the meantime, the petitioner, by way of an additional affidavit, shall bring on record the application so filed seeking which application so filed which led to the passing of the order dated 10/1/2025, comma. Written objection, if any, filed by the defendants in the said suit, as well as also provide an explanation as to why the order dated 10/1/2025 have been assailed
It's filed on.
only on
By
by filing the application on 26/5/2025 after more than 4 months. First, the petitioner shall also bring before this court the status of the present suit.
For admission, item 11.
Yes, what happened? You filed the status quo appeal. What has happened to the appeal?
Yes, I have, but it is. Another objection, that there is a 3200.
Huh?
There is a delay of 3200. We cannot explain that delay. That you have taken a view, no limitation is there, then nothing is simplified. We file.
You have not filed a limitation as.
We cannot explain the 3200 days, I cannot file. I cannot substantiate the delay.
So now the question is on the question of Order 7, Rule 11,
Yes.
as to whether it should have been. You are challenging the order dated 15/11/2021 on the ground of the bar contained in the Surface Act. Now, your specific case out here is, if I remember correctly, last time when we heard it, is that this order means you have already, he has come up on the basis of some internal document.
Yes.
And
There-
in
there
that
is
document onward,
Fraud has been committed.
Ah.
Fraud has been committed. And the property which are going to be attached by the bank, it is not the mortgage property. It was not the mortgage property. And the court said that as it is a allegation of fraud, so the suit will be proceed.
now the suit has been stayed.
Huh?
Suit has been stayed by this court.
Yes.
So he's having the advantage. He's having the advantage. isn't it?
They still-
He has an injunction order in his favor. He's having the advantage of the suit having not proceeded. And what best do you require if this matter further remains pending?
No, I am not pending. I have come against the rejection of the plaint. I have
Now,
come
if
for
I
rejection
can't,
of the
if I can't reject the plaint, if it's a question of fraud, when the question of fraud comes, if I can't reject the plaint, that is the reason why I asked you to file the appeal. Because that is how he's taking up the advantage. Although, if I remember correctly, he has given an impression before in the plaint that that land or something was not taken into consideration, was not the proper land or something to that effect, which you have already clarified by some other communication, isn't it? But that some other communication cannot be taken in a proceedings under Order 7 Rule 11. That is the problem for which I asked you to file an appeal.
I have filed.
I understand the problem, but the problem is allowing the suit to stay. That won't be proper. Then why don't you ask the court to exercise powers under Order 10? Before the court, ask the court to exercise powers under Order 10 and go for because the evidence is already complete. Not the evidence, what you call the pleadings are already complete. Once the pleadings are complete, so at the first hearing of the suit, why didn't you ask the trial court to come up with that and ask him as to whether this is the document or not? When both the parties come, the court can dispose it of. That seems to be the only way out. Because when the allegation of fraud is there, when he says something, maybe absolutely false, but I can't look into it under Order 7 or 11.
You have come against the clever, against, I have.
I understand.
That is there.
It's a case of very clever drafting.
Clever
But
drafting.
clever drafting.
Yes.
Clever drafting is what they have done. But for that, I think without this court, if you see the judgment where the clever drafting concept developed, is in the case of order in the 1977 4 SCC 497. Justice Krishna categorically says that if you cannot do so under Order 7 Rule 11, you then ask the court to do under Order 10. Isn't it? That is the judgment. See that paragraph? Say. Because you may have to think and ask the court, that we accept this. Ask the court for a decree. Let a decree be passed in respect to that, because he has given, because your basic thing is we are not going to do again anything in respect to this part of the property. We are only going to take action only in the other part. Isn't it your case? That is the only way out.
Given it,
Huh?
I will discuss the matter with the bank.
The problem arises there. What he has stated may be absolutely false, but I have to only read the plaint.
There,
Unless it is a case from a reading, do you say, Mr. Goswami, that from a reading of the plaint, just on a reading of a plaint, no case of fraud is made out? Can you say that? Can you say that? That from a reading of the plaint, no case of fraud is made out.
Lordship. Here I cannot say there is no fraud. I. Yes,
I
because-
understand
because
everything.
it's-
It's a case of clever drafting. But the question is, so therefore, from a reading of the plaint, one cannot say. But if I look into your written statement, or the documents you have filed along with the written statement, yes, there's no fraud. But I can't, for the purpose of Order 7, Rule 11, I have to only see the plaint. Problem lies there, na? So therefore, you exercise power under Order 10. Let me mention that paragraph. Go ahead. That is the only way out. Yes, Mr. Bidida. The person who is there in the trial court. You are the counsel in the trial court.
It's a clear case of fraud. In fact, if we rely on.
No, there is no case of fraud. Mr. Dekar, there is no case of fraud, but for perusal of the case, plaint is a case of fraud. Otherwise, it is not.
In fact, my lord.
They categorically say, Mr. Guswami, Mr. B.D. Goswami was not able to properly submit it before the court, but when Mr. P.C. Goswami submitted, then I realized, yes. Yes, therefore, yes.
That is why the appeal is, I have filed the additional affidavit. If actually wrong submission was made, that they have recovered the dues of pro forma defendant number 4. I've produced the certified copies, my lord.
Why
They're
should I
going-
look into that?
My lord, because that was the precise query your lordship had posed. Whether they are going to go ahead with the term loan in respect of this property. Then your lordship had said that let them make a bank make a categorical statement that will not go in so far as the home loan is concerned. That they did not make, my lord. In fact, they said we've already recovered the CC. I have documents to show that they are delaying the recovery themselves. In fact, they have been reprimanded by the recovery officer that why are you going so slow in the matter? Insofar as defendant number 4 is concerned.
We have not, recovery is going on. I have said it, not that recovery has been made. But if you go to your place, it's Schedule A, the boundary of the schedule land is not in accordance with the cell deed. And in the second cell deed, there is no boundary at all.
In fact,
And
there
if-
has
if-
been
if we-
manipulation of interpolation which I can. show
Making
to
a
you.
draft. We cannot make it joint property.
So what is your case, your plaint?
Lord, in the plane, if your lordship takes up, this particular property in question, my lord.
Which
what-
one?
My lord, the Schedule A property was I have 2 plots of land, my lord, both contiguous to each other. One measuring 1 kotha 10 meter. 2 kothas and the other.
Who on earth drafts such a long plaint?
Because my lord will be, if your lordship gives me some time, I can show.
Who
my
is the
lord,
filing counsel?
Lord, it was Mr. Nondi probably.
Huh?
Nondi, originally Nondi was.
Ah. It looks like it.
So, my lord,
Yes.
Just in a nutshell, my lord.
Okay, Schedule A and B is yours.
Yes,
Schedule A is 2 katha 10 lechas.
yes, my lord.
Schedule B is 1 katha.
One.
Then
Now, my lord, Schedule B, I have a RCC house which is holding number 2880. For 2 kotha 10 lechas of land, my lord, I take a home loan from Central Bank of India. my lord.
that is for Schedule A.
That is for Schedule A. Now, I take that home loan from Central Bank of India for 7 lakh rupees. Thereafter, I want more money, my lord, which is why I approach UCO Bank. Central Bank of India writes to UCO Bank that yes, we have the deposit of these title deeds, 2 kotha 10 lechas, you can give further loan, we are transferring those title deeds to you. After that, my lord, I avail the loan.
Thereafter, my lord, all of a sudden, the bank officials come and they want to attach my house in one court house. Then I
Schedule
get
B.
Schedule B. Then I get curious and I find and I apply for the certified copies from the DRT. Then I find that they prepare a document at page 90, my lord. 89 and 90. my lord.
What is that?
89, if your lordship sees. They say that this property in question, which I had created a mortgage by deposit of title deeds, this mortgage has been transferred to a loan of 3 crores availed by the pro forma respondent.
How?
That is their case, my lord. Page 89, if your lordship sees.
But it has your signature.
Yeah, that's the forgery, fraud and the forgery. I have made categorical statement. There are two things here, my lord.
So
If-
you are saying that page 89 is a
Yes,
false document.
now, my lord, this particular plot of land at page, this particular plot of land at page 89 was already mortgaged back in the day of Central Bank of India for my initial home loan. And this now has been shown to be mortgage in respect of a cash credit availed by Messrs. Lohit Construction.
So how are you connected with that?
I'm not connected at all. Then they say that I stood as a guarantor, my lord. Now, my lord, will see here, my lord. It says this is to confirm that I have deposited on 13/3/2009, my lord. Now, if I had deposited for the home loan way back in 2007, how can I again deposit it in 2009 if you've not released the title document to me? Now, second part, my lord, serial number 4 in the details of document, it says NEC 656-53/2010.
So what are you asking here?
I am saying that this entire document,
Declaration that the creation of collateral security of Schedule A land and the house against loan and of cash credit given to the defendant number 4 and 5 by the defendant number 1 is an act of fraud. But Schedule A is 2 Katha Telnet.
yes, my lord.
But what do you say about Schedule B?
Schedule B now, the interesting part, your lordship
But
will
your RCC house is in Schedule A or B?
my house, RCC house, which they are showing here, my lord, for a moment, page 90, if your lordship.
But
sees.
your prayer,
Yes, my lord, for a moment, page 90, if your lordship sees.
no, I'm saying about page 40.
Yes, my lord. So what they have
Where-
done
But
fraudulent.
why
This is
you
the second
say
fraud
the
then.
creation and house, Schedule A and house against the loan?
Yes,
So house is in Schedule B.
yes, my lord. House is in schedule B. Now your lordship will come to page 92. For a moment, your lordship will understand what the fraud is. This is the second part of the fraud. This is the Form C, my lord. Form C, your lordship finds this is against the cash credit Lohit Construction. Now, this was annexed as this was annexed as an exhibit in the DRT proceeding. Now, if your lordship will skip over to page 90, the same Form C at page 92, at page 90, curiously contains a schedule.
2 Katha Telnet, sir. The Schedule A.
Schedule A down below, and a 3-storied building, my lord.
Where?
And it's page 90. The same document at page 92 doesn't have this endorsement. At
The
page,
land and 3-storied building in the name of Korea measuring 2 Katha of 146 patta.
now your lordship will come next to page 91. 91 details of document, serial number 7, if your lordship sees. Extract of holding number 2880. Has your lordship seen it?
Where?
Page 91, serial number 7, details of documents.
Ah.
So they now want to get the hold of this 2880, whereas 2880, if your lordship sees at page 60, is situated in 1 Katha 10 lechas of land. Page 60 is the holding extract. So two frauds, very clear fraud, my lord. First, they take my property, which I had mortgaged to them in trust as against my home loan. They are showing that no, it is also mortgaged to a CC. And that CC title, memorandum of title deeds is created in 2009, where they say there is no encumbrance.
So is this not your signature at page 90?
I have said that I was made to sign on a dotted line for my home loan, and these documents are now given to. And in the written statement, the answer is even more explosive. If your lordship sees the written statement, my lord, page 152 for a moment, perhaps they want to retract from this admission, which is why they want to get it rejected under 152 Order 7 Rule 11, because at page 152, what they've said is completely rehearse the law, my lord. Paragraph 9. The statements made in so and so are not fully correct and hence not admitted by the answering defendant. The answering defendant respectfully begs to state that under the terms of
Why
the
should I
sanction.
look into this?
My lord.
I'm not going to look into all these things. My only query is.
Well,
Order
otherwise,
7.
the pleadings are there, my lord. Clear pleadings of fraud. In fact, I would say half the fraud is substantiated by pleadings only, both theirs and mine. And that is the precise reason, my lord, they cannot state on affidavit that this property we will.
So what is your case in the plaint?
Plaint cases, my lord, first of all, this Schedule A property was never mortgaged for the purpose of CC of a 3 crore loan availed by
In
Udomit
favor of the defend
Construction.
number 4 and 5.
Yes, it was only for the
In your
home loan.
suit.
That
The
is one
suit
part.
is, you are the owner of Schedule A and
B.
Schedule B.
My lord.
Schedule B has a 3-story building which has a holding number 2880. Now Schedule 1A land was mortgaged initially to Central Bank. Thereupon this mortgage was transferred to the UCO Bank. UCO Bank, you asked for more loan
Yeah,
for
it
which
was
it got transferred.
transferred.
Now because of that, now UCO Bank, but what they did is later on after 2-3 years, they came over. They came over and wanted to take over that property. Then you realize out there how the property was taken, then they came to know from DRT that these are the 2 documents, fraudulent documents being created.
Yes.
For which you say that there is no case of all these, what you call, the creation of the collateral, the mortgage in favor of the defend number 4 and 5 on your property is a fraudulent,
Yes.
for which you have filed a suit.
And second part.
That's all? That's all?
That's all. In fact, the recent judgment also says, my lord.
Okay.
Let's not check. It is their document. So one thing.
Their document where?
No, it is on page 67.
Yes.
Page 67
Ah.
is the central bank sanction letter.
No, no.
No.
Mr. Goswami, all these things, I cannot look into it.
Yes.
I should not further spoil the time of your learned colleagues. I should now
I
dismiss you.
simply mention one thing. One thing I
Hmm.
he has taken loan for construction of the first floor of the building standing on the Schedule A land. And against that we have, it has been extended, enhanced to 22 lakhs. But in the schedule he has said RCC building rooms and Assam type house. He has not constructed by receiving 22 lakhs, he has not constructed the first floor. By which he has deceived the bank, if he is correct.
Mr. Goswami, there's no quarrel that he may be a biggest fraud. But for the purpose of that, the allegation shows that the UCO Bank is the biggest fraud. So I have to only look into the plaint where it says that the UCO Bank is the user's fraud. And as on perusal of the plaint, it is shown that it is a case of a fraud. So therefore, once fraud is there, then the jurisdiction is ousted. So the question, this has to be only decided by the civil court. Therefore, the court may be right So I can't exercise jurisdiction under 115. Matter in. Okay.
Then
Now
we
let-
time bound the civil court to dispose of the matter as early as possible.
Which one?
Civil, because it was not proceeded.
Because of the stay, you have helped him to get.
No, not stay, just 1 year. Before that, from 16, it has not proceeded.
But you have only filed a written statement. Let them give you evidence. Chalo.
I think no issues has been also framed. No
Hmm,
issues
they
has
will do it.
also not framed.
So
Nothing is-
immediately you should get it done. Anyway, Lakho. Heard Mr. P.C. Goswami, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so, who appears on behalf of the respondent. The jurisdiction under section 115 of the Code of Civil Procedure 1908, for short the code, have been invoked to challenge the rejection of the application filed under Order 7, Rule 11D for rejection of the plaint by the Court of the Learned Civil Judge Senior Division Number 3, Kamrup Metro at Guwahati, hereinafter referred to as the Learned Trial Court. Next. Mr. P.C. Goswami, the learned counsel appearing on behalf of the petitioner, submits that by virtue of section 18 of the full name likhi diyo, Surfacey Act, for short the Act of 2012, 2002, the civil court had no jurisdiction in matters specified under section 17 of the Act of 2002.
Not section 34 of the section 34 of the surface,
Section 18,
34
section 34. Section 34
of the
of the
surface.
Surface Act. 17 only. In relation to matters specified in section 17 of the Act of 2012. And as such, the suit was barred for which the plaint ought to have been rejected by the learned trial court, which the learned trial court failed to do so, while exercising its jurisdiction, for which the instant proceedings have been filed. Full stop. Taking into account the order dated 15/11/2021, which is impugned in the instant proceedings, being an order passed under Order 7, Rule 11, being an order invoking the jurisdiction of the learned trial court under Order 7, Rule 11D of the code. It is relevant to take note of that it is a well-settled principle of law that while adjudicating an application under Order 7, Rule 11D, the court is required to only look into the contents of the plaint as well as the documents filed along with it for the purpose of ascertaining as to whether the plaint whether whether the plaint is required to be rejected as from a reading of the plaint, the suit is barred by law. Full stop. Under such circumstances, for the purpose of deciding the present application, it is relevant to take note of the brief facts which led to the filing of the suit, and as to whether the suit can be said to be barred under Section 34, the Act of 2002. First, the case of the plaintiff, the respondent herein, who instituted the suit, being title suit number 240/2016, is that he is the owner of 2 plots of land. First, the first plot of land had been specifically described in Schedule A to the plain, and the second plot of land is described in Schedule B to the plain. It is the further case of the plaintiff that the Schedule A land at measures 2 kata 10 lechas, which is covered by DAG number 221 bracket 222 old oblique 146 new of KP Pata number 118 The other plot of land is also covered, which admeasures 1 kata also is covered by the same DAG and Patta number, isn't it? It is, however, relevant that from a perusal of the plaint, it is seen that there is a 3-story building in Schedule B land, which is the 1 kata plot of land, wherein there is a holding number 2880. First, next. It is the further case of the plaintiff that the Schedule A land was initially mortgaged to the Central Bank of India for availing a home loan of rupees 7 lakhs.
50,000. 7,50,000.
7,50,000. Subsequently, as the plaintiff required further money, he took and the appellant and the respondent and the defendant number 1 was agreeable to provide further loan, the mortgage over the Schedule A land was transferred by the central bank to the UCO Bank. And in that process, the plaintiff took a loan of rupees 22,50,000.
22 lakhs.
22 lakhs. It is the further case of the plaintiff that And have you paid off that loan? 22 lakhs?
No, my lord. No, I've not. I've been requesting OTS, they have not replied. Para 25 onwards.
It is the further case of the plaintiff that in the last week of February 2016, some unknown persons started to come to the residence of the plaintiff, which is in Schedule B land. Full stop. The plaintiff made inquiries and could find and was surprised to learn that the said Schedule B land and the house standing thereon was being proposed to be auctioned by the respondent numbers 1, 2, and 3, defendant numbers 1, 2, and 3. First, under such circumstances, the plaintiff inquired with the defendant bank as regards such action, such rumor of auctioning of the properties belonging to the plaintiff. And the plaintiff was shocked and surprised to come to learn that the respondent number 1, the defendant number 1 had sanctioned the loan in favor of the defendant number 4 of an amount of rupees 23 crores and odd, isn't it? Wherein the plaintiff was shown as a guarantor and creating equitable mortgage of the Schedule A land. The plaintiff was also surprised to learn that in the creation of the said equitable mortgage, not only the Schedule A land has been shown, but the 3-storied building had been also shown. The plaintiff categorically denies in the plaint that the plaintiff was any guarantor, was not, that the plaintiff was a guarantor to the loan cash credit facility, so cash credit, na?
Cash credit.
Facility which was afforded to the respondent, afforded to the defendant number 4. And the plaintiff had any part in the creation of collateral secured, plaintiff had any part, had taken any part in such transaction. It is under such circumstances the plaintiff instituted the suit alleging fraud being committed by the defendants in concert and collusion with each other, and thereby to take over the property belonging to the plaintiff. First, the plaintiff therefore sought for the following declarations, which is reproduced hereinunder, page 40 and 41. First, for following relief in the suit, which is quoted hereunder. 40. First, in the backdrop of the above, this court duly takes note of the order being passed by the learned trial court dated 15/11/2021, wherein the learned trial court was of the opinion that as the allegation of fraud was being alleged in the suit, comma, the civil court would have jurisdiction in as much as the tribunal under the Surfacai Act, that is the Debt Recovery Tribunal, have not been entrusted with the power to do so. Under such circumstances, the said application filed under Order 7, Rule 11D of the filed by 11D by the defendants numbers 1, 2, and 3. 1, 2, and 3. 1, 2, and 3. Who are the but here only one petitioner, na? Filed by the defendant numbers 1, who is the petitioner herein, was rejected. First, I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. First, this court have also perused the plaint as well as the documents which were filed along with the plaint. Apart from that, this court have also perused the impugned order. First, the judgment of Justice Pardiwalas?
Yes. Paragraph 24 onwards.
Where is the question of fraud?
Fraud is 25, 24, 25, and 26. 26, my lord, refers to paragraph 51
Huh?
of Mardia, my lord. Paragraph 26
6 is about Madhya. 27 is so and so. Where is the fraud?
But 14 to 18 talks about the jurisdiction part.
The law which is well settled would show that mere allegation of fraud in the plaint would not overcome the bar under Section 34. In the case of Electro Steel Casting Limited versus UV Assets Reconstruction Co. Limited, reported in 2022 to SCC 573, the Supreme Court opined that mere allegation of fraud would not oust the jurisdiction under Section 34 of the Act of 2002. The allegation of fraud should be with detailed particulars should contain due particulars as to how the fraud was committed.
Paragraph 14 to 18 could be.
Huh?
Paragraph 14 to 18, my lord, deals with only those matters which are covered under 17, and whether the creation of mortgage is illegal or not, that only the civil court will decide on. Paragraph 18.
Submission. It was further opined by the Supreme Court in the said judgment that allegations of fraud without any particulars and only with a view to get out of the bar under Section 34 of the Act of 2012, and by such a clever drafting, the plaintiff intended to bring the suit maintainable despite the bar under section 34 of the Act of 2002 was not permissible, and such actions should not be approved. Full stop. Therefore, the question which arises is on the basis of the allegations contained, can it be said that the allegations were mere allegations of fraud, or the allegations to contained in the plaint had detailed material particulars, thereby to oust the jurisdiction of the Debt Recovery Tribunal. Full stop. Mr. B. D. Decker, the learned counsel who appears on behalf of the plaintiff, submitted that along with the plaintiff had filed various documents which is required to be taken into account in view of the judgment of the Supreme Court in the case of Liverpool, isn't it? Liverpool. The learned Liverpool versus so and so. Huh? The learned counsel drew the attention of this court to document number 17 as well as the document number 18, so filed along with the plaint. He submitted that the signatures appearing that the plaintiff did not sign these documents, and the plaintiff has reasons to believe that at the time of taking loan of 22 lakhs, the plaintiff was asked to sign certain documents, blank papers,
Says dotted line.
was asked to sign on certain dotted lines wherein the plaintiff had duly signed. Full stop. It was alleged that those documents, have you mentioned it in your plaint? That those documents which have been mentioned out there, what is written inside these
These
documents?
were discovered only thereafter. Mullah. I've written that para 25 onward. I've said that these documents I got from there. And main issue is page 68. This property was already mortgaged to them only for the house loan. The same property.
No. Have you mentioned in your pleadings that
Yeah,
these
yes, I've said. Yeah.
handwritten things were subsequently inserted?
Yes. That is my categorical statement, page 68.
Page?
I'm sorry, paragraph, I'll just. Page 29. Mullah. '29 and para 29 and para para 37, page 23 and 27.
Para?
Para 29,
He referred to paragraph 29 and paragraph 37 of the plaint and submitted that these are specific allegations made This court have duly perused the documents being document number 17 and 18, which have been filed along with the plaint, and have also perused paragraph number 29 and 37. And 38 of the plaint. And it is seen that those documents, by these averments made, there are clear allegations of fraud. Full stop. He further submitted that as the loan, as the mortgage deed, as the title deed in respect to Schedule A land was already, he further, the learned counsel appearing on behalf of the plaintiff further submitted that it has been categorically mentioned in the plaint that as the title deed was deposited with the defendant number 1 bank
25.
for the purpose of taking the loan of 22 lakhs, comma, in the year
2008.
2008, comma, the question of again the question of again depositing the said title deeds for another loan does not arise. And these are specific allegations contained in paragraph
25, 26, 29, 30, 37, 42.
give me 1, 2.
That's a long.
But the problem will be how you prove it. Making a plaint like anything, huh? 75 paragraphs plaint.
26.
People
and
will
20
laugh.
26, 29, and 30.
So and so. First, taking into account the above, this court is therefore of the opinion that a reading of the plaint from a reading of the plaint, it cannot be said that the allegations so made in the plaint were mere allegations of fraud, but the said allegations of fraud were but there were allegations of fraud with material particulars stated therein. Considering the above, it is therefore the opinion of this court that the learned trial court was justified in rejecting the application for rejection of the plaint. First, plain. Inasmuch as the jurisdiction of the learned trial court was not ousted, by virtue of section 34 of the Act of 2002. Full stop. Considering the above, this court does not find any merit in the instant proceedings for which the instant petition stands dismissed. Full stop. The interim order so passed by this court thereby staying the further proceedings. Title suit number 240/2016 stands vacated, and the parties herein are directed to appear before the learned trial court on 25th of June 2025 for further proceedings of the suit. Before parting with the record, this court, however, finds it very pertinent to take note of the submission of Mr. P.C. Goswami, the learned counsel appearing on behalf of the petitioner, who submits that the suit is of the year 2016 and there is an injunction order being passed thereby restraining the petitioner to take any action. Full stop. The learned counsels have further submitted that this is the recovery which is being sought to be done is money belonging to a public nationalized bank.
Public,
Nationalized bank, public, what do you say?
public money.
That I will say, the nationalized bank. And as such, the money is a public money. He therefore submitted that till 2022, the suit is still, a suit filed of the year 2016 was still at the stage of framing of the issues. He therefore submitted that this court may pass appropriate directions for directing the learned trial court to dispose of the suit on an early date. Full stop. This court have given a due consideration to the said submission and is of the opinion that the suit as on date is almost a decade old. Considering the above, and further there being an injunction order in favor of the plaintiff, thereby restraining the defendants to act. This court would request the learned trial court to expedite the disposal of the suit, taking into account the business of the court, This court further requests the learned trial court to preferably dispose of the suit, preferably within 10 months from the date of the present order, from the date of appearance of both the parties. Records was full. Records, no. Record is in.
Item 51 fixed at 2 p.m.
Part of the judgment is at page 104. relevant part of the judgment is at page 104.
With the judgment,
Appellate judgment. Absence has been recorded, then merit was discussed and then dismissed.
is a judgment also directly on the point with the Supreme Court.
Yeah. Definitely.
And another thing is, there seems to be a mistake. If the allegation is that they were not allowed to file their cross-examine the plaintiff witness or whatever may be, that is a question which will come within the ambit of 105.
Yes, my lord.
You don't need to challenge it separately, that
Yeah.
order.
So that's why I asked the other day that this is also another question.
But that is on a question of merit, na?
Yes.
That I don't want to touch it,
Right.
because that would not be proper.
So, Prabodh Chaudhary, my lord, relevant paras are 6, 7, 8.
But Mr. Ulster, the learned counsel appearing on behalf of the appellant.
Subject to lordship consideration. Madam, what has happened, we have taken instruction. In fact, I also personally talked to the counsel who appeared for the respondent there to find out, because the instruction is there before the presiding officer who passed this order. Before him, one Utpal Das possibly was the presiding judge. Before him, they appeared on 2-3 occasions, but ultimately judgment was not delivered. Then this present president just came. The counsel, he is a senior counsel, but is very aged, about 70, maybe say above 70. He says he doesn't very specifically remember. He says maybe in the initial stage before this presiding judge also, the appellant appeared and argued.
And
Argued. If the matter initial, if it is part hard matter, and then on the next date he doesn't appear, possibly it will not be a case of non-appearance, possibly subject to. If first day he
so
appeared,
are
he
you
argued.
saying,
My lord.
which means This court will have to call for the records.
Possibly, that is what I'm saying. Or your lordship will give me time, we will obtain certificate for you to find out before this judge on how many dates the matter was litigated. I can find.
Means there's no meaning. You see, the question is,
Right.
here,
Reflected in
the court does not say that earlier it was heard.
Well, it doesn't say,
Then
doesn't say.
it's
That
not-
I
then
repeat.
the court should have said.
Yes.
So it was date fixed for a year. Does
And
not need any interference in that. So he,
maybe
for the
fear.
respondent states, heard the learned counsel for appeal and remained absent unread for the considerable period. Kindly see paragraph 6.
And repeated also, subsequently also.
No, kindly see paragraph 6
My lord.
of the impugned judgment. Heard learned counsel for the respondents,
Yes.
appellant remained absent unrepresented for a considerable period. So it couldn't have been
Well,
uttered.
Yes, my paragraph 8 also last sentence like that.
Furthermore, the
Furthermore.
appellant is either also absent, remained absent
For the
unrepresented for a considerable. So therefore, what is required is, I am now remanding the matter back. And by virtue of 4126, I am fixing a date for hearing.
My lord.
Then you don't appear, it gets dismissed.
My lord. So they are on notice.
Huh?
They are on notice that it's the date.
Because I'm fixing it, because the,
A date may
To
be
be-
given for hearing there.
huh?
A date may be given for hearing there.
No, I'm fixing a date for hearing, not given for hearing. 26A, 26A. Where the appellate court remands a case under 23A of claims issue on so and so, it shall fix a date for appearance of the parties before the court from whose decree the appeal was prepared for the purpose of so and so as to further proceedings of the suit.
Yes.
Heard Mr. O. Losco, the learned counsel appearing on behalf of the appellant, and Mr. D. Mujumdar, the learned senior counsel assisted by so and so, appearing on behalf of the respondents,
My lord. 5, 6, 7.
and Mr. K. Bhattacharjee, who appears on behalf of the respondent numbers 5, 6, and 7. 1, 2, 3, 4. This court, by an order dated 4/6/2025, admitted the instant appeal by formulating the following substantial question of law. Did you? Pusto. This court duly heard the learned counsels appearing on behalf of the parties on the question as to whether the said substantial question of law duly arises in the instant appeal, is involved in the instant appeal. Pusto. It is seen from the this court had further perused the impugned judgment and decree, impugned judgment and order dated 30/9/2022, passed by the learned court of the learned court of the district judge, Karimganj, in title appeal number 4/2017. Footstop. A perusal of the said judgment, and more particularly at paragraph number 6 and 8, clearly shows that the appellant remained absent on the date on which the appeal was called for hearing, as well as for a considerable period of time. Pusto. The question therefore arises as to whether the learned first appellate court was within the jurisdiction to dismiss the appeal on merits, or should have dismissed the appeal in terms with order 741 rule 17 of the code, that is terms with order 41 rule 17 1 of the code. Footstop. This court finds it relevant to take note of the judgment of the Supreme Court in the case of Pramod Chaudhary and Chaudhary Das and another versus Mahamaya Das and others, reported in 2020-18 SCC 701, wherein the Supreme Court explained in paragraph number 7, 8, and 9 that when the appellant does not appear on the date when the on the date fixed for hearing or on the adjourned date for hearing, the court can only dismiss the appeal. The court cannot dismiss the appeal on merits. Paragraph number 7 to 10 of the said judgment being relevant is reproduced hereunder. Taking into account the said, this court therefore is of the opinion that the substantial question of law so formulated by this court on 4/6/2025 duly arises is involved in the appeal. Accordingly, the appeal stands allowed. This court, further taking into account the provision of Order 41, Rule 26A, therefore, this court, therefore, by taking into account the provision of Order 41, Rule 23A, and read with Order 41, Rule 26A, remands the appeal back to the court of the learned district judge. Karimganj for adjudication of the appeal in accordance with law. Full-stop. For adjudication of the appeal afresh in accordance with law. Full-stop. This court further taking into account that both the parties are duly represented, directs the parties to appear before the learned first appellate learned court of the district judge Karimganj on 7th of July 2025, which shall be the date fixed for hearing. Full stop. The learned court of the district judge Karimganj shall hear the appeal on the said date, or shall for hearing of the appeal. Full stop. Before parting with the record, this court had duly taken note of the impugned judgment and order, and more particularly the observations so made in paragraph number 8. And it is the opinion of this court that the learned first appellate court this court, it is the opinion of this court that the learned first appellate court had erred in law in observing that there was no challenge to the order passed whereby the evidence, the cross-examination of the plaintiff witnesses were closed. Inasmuch as when an appeal is preferred against the judgment and decree, comma, section 105 of the code permits the appellant to raise all such grounds of objection which, in respect of which appeals are not permitted under law by the code. Appeals are not permitted of orders under the code.
Very
See?
interesting. I'm just indicating, my note. 2014, he submitted the evidence on affidavit. Then 3 years he didn't turn up for cross-examination. Then a decree is passed. Somehow his appeal is dismissed. Appeal was dismissed in September 2022. 3 years it remained pending. So without doing anything in the suit, he is somehow.
So therefore, this needs to be clear. I've done it and let them do it.
Yes.
In fact, if we have not done it, if the court holds it, because the court, if these are the problems.
Right.
The court should have known about 105.
Simply.
First of all, should have dismissed for default and then proceeded. Then he would have been compelled to come.
Yes.
That is the problem with the
That is the
courts.
problem.
Daily list
That-
item
that
12.
gave- That gave him the oxygen.
Huh?
That gave him the oxygen. Obliged.
Given? Yes, what is this?
My lord, I am for the respondent number 1.
Ah.
My lord, in this case, the wife, I was the plaintiff.
Oh, there is no stay,
There is no stay.
and therefore not bothered. None appears on behalf of the petitioner on call. Mr. So-and-so appears on behalf of the respondent. It appears that the petitioner is not interested in the proceedings for which the petition stands dismissed for non-prosecution.
Much of it.
13.
Who is appearing?
Transfer petition, my lord.
Anybody appearing? Their names have been shown in the Wakalatnama. None has appeared today also. Okay. You are,
I am for the petition,
you want the transfer
transferment.
from?
From my principal judge, family court, Nolbari, my lord, to Chirang, district judge
Why?
Chirang.
Why do you want?
My lord, we both are residing at Basugao. my lord.
Huh?
Husband and wife both are residing at Basugao,
Then?
Chirang, my lord. My 2 cases also pending before the Chirang court, my lord. And my 2 daughters also starting at Chirang, my lord.
Everybody is in,
Suddenly he
Where?
filed a case.
everybody, but he has put his address as different.
My lord, in
Huh?
page number 17, he has filed a petition mark for dissolution of marriage, my lord. Here, he has shown his address is at Nolbari, my lord.
Hmm.
In affidavit, but in the affidavit also, my lord, in that case, page number 24, my lord. Rajachorong Chirang also written, my lord. Page number 24, my lord.
Where?
Page number 24, my lord.
Son of so-and-so village here presently residing. Okay. Hello, transfer query. You go and file your written statement. You have not filed your written statement?
No, my lord, this is the stay, it has been statement.
I'm asking you, have you filed? No. File your written statement before the court at, where do you want? Sirang.
Chirang.
Okay, Sirang on 21st of July.
Obliged.
14.
আজি কিমান 21st নহয় 4th of August.
My lord,
Yes. So fat transfer petition, what is this?
My lord, this is a.
And you have Mr. M.A. Sheikh
Yes,
This transfer matters, he doesn't appear, that means it is a something very high stake matter. Yes, what is this?
Well, that, my client is an advocate. He was working with
Ah,
my client practicing in Guwahati, man. Practicing in Guwahati originally, but
Ah.
thereafter he shifted to Bilashipara.
Hmm.
Now he wants that wife should live with him.
Huh?
And at Bilashipara. At Bilashipara.
wife
is the
should?
Live at Bilashipara because the husband shifted to Bilashipara.
So you have filed a case for what?
This petition, here for restitution of conjugal rights. She is not cooperating with me.
So you are an advocate.
Yes, ma'am,
You were earlier practicing here.
in Guwahati.
Your wife was with you,
Yes.
was a petitioner, and she liked the weather in Guwahati. Now she doesn't want to go back to Bilasipara. That seems to be the dispute,
Yes,
isn't it?
they have the permanent accommodation at Guwahati, my lord, Hatigao. Own landed property, my lord. There is a, my lord, 2-story RCC building, my lord.
Hmm.
And 2 children, my lord. One is.
And
my lord,
why are you staying here? There's a torture. These photographs are given.
Yes, my lord.
My goodness. Police case?
Police case, my lord, that was not registered.
You've not given police case.
They filed, my lord, but that was
FC criminal,
later on amicably settled, my lord.
settled. Then what happened?
And
Now, which case you are referring to?
My lord,
Is this case pending?
yes, my lord. My lord,
394.
The husband of the petitioner, my lord, he filed a case, my lord, TSR, my lord, at Bilasipara
Hmm.
for restoration, my lord. And in the meantime, my lord, he also filed another complaint case before the Kamrup Metro, my lord.
Hmm.
That is, my lord, at case 90.
Hmm.
And we have, my lord, appeared and filed our written statement in that case, my lord.
Hmm.
Case 90. And 92 is the, my lord, plaintiff, my lord. CR case 484, 2024.
Which case are you seeking for transfer? Where? Where is the
That is-
plaint?
Yes, my lord, that is my lord, at page 24.
Hmm?
Page 24.
Page 24. Hello. Why are so many people out there? So many address given, so many performers.
My lord, kindly
A
see, my
fight
lord.
between Mr. MSC. What is this? Why a
lord,
fight between
Mr.
husband and
Mr.
wife is being scattered out there with performer defendants? Why?
The sister.
I know, he must be an expert in civil law. So must be because of that, he doesn't want to
But,
take a risk.
That may be that unnecessary party, my lord. But thing is this, my lord. She living in Guwahati, leaving me, I shifted to Bilashipara.
Hmm.
So, my lord, now she want to drag me to here. My lord,
Hmm.
my livelihood is my profession.
Hmm.
I do not continue here.
Hmm. Hello?
And my property, landed property also there.
But you have landed property here also.
Yes, sir.
Here I,
Plots, my lord,
while-
3 plots,
during
3
my,
landed property, my
during
lord.
my profession, my lord, I purchased some property, that's
Mm.
all right. But now, my lord, if she do not continue with me, my lord, there's problem.
My lord, the petitioners, my lord, they have 2 children, my
You
lord.
want to give divorce? You want the divorce ground on the
My
ground
lord,
of,
not divorce, my lord, I want restitution of conjugal rights.
so you make it a prelude to a divorce.
I want to continue with her.
Okay, we transfer it. Suit for restitution of conjugal
My
rights.
lord, in that case, my lord, your
Family
lordship,
court.
your lordship would be pleased to see the prayer from civil court, page 15.
Yes.
From the Court of Civil Judge Junior Division,
Hmm.
Bilashipara to the Court of District and Session Judge.
Hmm.
Actually, my lord, my humble submission,
possibly this prayer is wrong.
Why?
Because family court is here. Family court is functioning, all family matters should go to the principal judge family court, not to the district judge.
No, the question is, this is a Muslim, yeah, can it go? Whether the family court can deal, oh yes, it
No,
can.
no, Family court has got jurisdiction.
Chalo, transfer to family court. You appear
Yes, ma'am.
and file your written statement on 4th of August.
Written statement, I am to file, my lord, because,
He has to file. You are the petitioner.
yes, ma'am, opposite, yes.
You are the petitioner there. Will be transferred on 4th of August. Both parties will appear before the family. And he will file. his-
Oblige, your worship. Oblige, ma'am.
15.
What is this? What are you challenging?
Lordship, the impugn order is, Lordship, at page 74. It's an order of interim maintenance, Lordship,
How much?
15,000, Lordship.
Huh?
15,000.
So you can't pay.
Yes, Lordship.
Why?
Lordship, my income is 30,000, around 32,000, Lordship.
Huh.
And I have my younger brother and my parents, all ailing parents,
And?
all ailing parents, Lordship. And I have only this petty shop, Ghumti shop, Lordship. And learned trial court has not considered the basic things required under section 24, Lordship, the respective income of the parties. As per the decision, leading decision of the Honorable Supreme Court, Lordship, Rajneesh versus Neha, all the parties are required to submit assets and liabilities. And accordingly, we have submitted the assets and liabilities, and that has not been considered, Lordship. Because they are, it
Where
is
is
the
the assets and liabilities?
Lordship, annexure 5 and 6, Lordship, page 40 to 45, Lordship.
What is your business?
Lordship,
What is your business?
my
Is
business
your
is that,
HS pass?
yes, Lordship. He is BA pass, Lordship.
Is BS pass?
He is BA.
Where is she filed her assets and liabilities
Yes, Lordship,
page?
it is in page 46, from 46,
Page 46 is yours.
sorry. 40, Lordship.
BA pass. So she has
She has
no
also
income.
concealed many things.
Hmm?
She uh, had tuition and she earns also, but she had not stated divulged in these earnings in here. So I'm on not on that, Lordship. As because I am earning as per my income tax report assessment returns, Lordship. I am earning and I have liability also. The assets and liability, what is my earning and what is my liability, that has not been looked into and not been discussed in the impugn order, Lordship. So I am ready and I have been paying, Lordship, as per the impugn order, I have been paying 15,000 per month and I have also paid the cost of 30,000 as ordered, Lordship. But I am facing very hardship. I am to maintain, being the elder son, I am to maintain my old ailing parents and my younger brother, Lordship. So
What is
it
your
is-
business? Some computer shop, na?
no, Lordship. It is a cloth shop, Lordship,
Huh?
in a municipal market. It is a cloth shop in a municipal market, Lordship, at Huzai. Page 2 TS.
Yes, Mr. Ganguly.
Fact remains that, there is a son also, it's not
Huh?
only the wife. They have a son also.
Son is with
Son is
you.
also with me. Son is studying in a school. And my lord, he does not want to pay 15,000. And in fact, my lord, they've gone to the extent of filing a Jamabandi. A Jamabandi they have filed in the lower court and also annexed here, which is of the year 1999.
Huh?
Of the year 1999, to show that his father, the petitioner's father, husband's father, has only one land. But I have annexed, my lord, the latest Jamabandi, which shows that his father is the owner of 3 plots of land within the Hojai town. So, my lord, with a very malicious intention, the Jamabandi of the year 1999 has been, handwritten Jamabandi has been annexed. Whereas, my lord, today it is all computerized, it is all available on record. That is the first aspect. Second, my lord, he has annexed his income tax only up to 2021-22, whereas the affidavit of assets have been filed in the year 2024. What prevented him, my lord, from disclosing that why his income is so? Lord, this is an amount of 15,000. It's a school-going child. There is a school-going child involved.
Where is the child studying?
It's a Sacred Heart School, my lord, which is a well-known school in Tesco. And he is 4.5 years old. He's not even 5 years old. There are some basic expenses considering the inflationary aspect. And
You are staying with?
I'm staying with my parents. And the one more factor is there, you know, that as per the affidavit of the petitioner, he is supporting his younger brother, who is almost 23 years old, and he's said to be preparing for competitive exam. My lord, his duty to his wife and child perhaps take precedence over his duty towards his younger brother, who is of a majority age, who has crossed the majority age and is said to be preparing for exams. That is as per his affidavit. He's, as per his affidavit, he's spending 5,000 per month on his brother. Look, here, and he has categorically said one thing in his, in the learned trial court, that I will not pay the wife because she has gone and spending time there in the parental house, but I'm ready to support my child. So in view of this statement, he has denied his liability to pay any amount to the wife at all. And it was he who went ahead and filed the divorce suit. 15,000 under today's circumstances, considering the standard of living of the parties, this is not an unreasonable amount by any standard. My claim was for 20.
So I should do one thing, make that 15,000 nail and give you further liberty when the 8-pay commission strikes in. There would be an inflation to again file for extra.
Lordship,
So I do one thing, I maintain this 15,000, and I think next year most likely the 1 or 2 years there will be an 8-pay commission. So then in that regard, I give him the further liberty to ask for more.
Lordship, I'm this a PT businessman, Lordship. I'm having only Ghumti. The Lordship will see that the rent of the Ghumti is 350 rupees. What is my the position, Lordship? My business position, Lordship.
Mr. Counsel, are
So I'm not-
you just suggesting me that when you are taking a municipal holding,
Yeah.
Gumti, it would be more than that? I also take sometimes bench 4-5 matters.
No, Lordship, the respective tax and liability and respective income should be considered. She is also doing, having qualification of BA pass, Lordship, and I am not saying that I will not pay. Lordship, the Supreme Court in many cases have considered that the 25% of the income of the, as per the return of the income tax, it should be considered as a reasonable. Lordship, what I'm on the, that those aspects are not being considered in the implain order, Lordship. Implain order, only it is written that both the parties have filed assets and liabilities. That has not been considered, that has not been looked into to find out what is the reasonable quantum, Lordship. I am not saying on that, Lordship. If it is 25%, that will be 8,000, Lordship.
Your parents are alive,
Yes, Lordship.
and what is
Yes,
their
what-
income?
in the liability, Lordship, I am giving their aid also.
And what did your father do?
She's 65 years of age. Mother is 59 years.
What did your father do?
No, Lordship, they are dependent on me. They are dependent on me, and they are ailing, Lordship. I have also submitted this, some medical certificates also there in the case, and along with my affection liability, Lordship. I have to, being an eldest son, it is also my duty to look my parents also. And I will certainly pay to my wife during the pendency of this divorce case, and also the children. But it should be reasonable to me also, Lordship. I can't.
So what is reasonable to you?
Lordship, what I am suggesting, Lordship, I may submit, Lordship. Supreme Court says that it should be 25% of this so and so. I may submit that it should be 30% of my income, Lordship. If it is 32,000, so Lordship, 30%, 9,600, Lordship, 10,000 may be reasonable for me. At least I can afford, Lordship. Because
Supreme Court said 25% in the context of how much?
25% in the context of the income.
No, in the context of the facts of that case, how much?
It was.
How much was the income?
30,000 per month, probably, Lordship.
Show me that judgment.
Lordship. 2017 judgment, who has relied the earlier old judgment also, Lordship. Para 15, Lordship.
In the case of salary.
Lordship.
Salary.
He was, in this case, he was salaried person, but here.
63,000 was his salary. And after deduction of 24,000 on GPF and 12% on income tax, further to February, the net salary of the appellant is stated to be 95,000.
Yes, Lord.
Following so and so, it was held that the 25% of the husband's salary is so and so. Since in the year the net salary of the husband was 95,000 per month, the High Court was justified in enhancing the amount. However, since the appellant has also got married second time and has a child from the second marriage, in the interest of justice, we reduce. You get married? Get married?
No, Lord.
Will reduce?
That has been considered, Lordship, 25% of the amount.
No, 25% of that 95,000 appears to be good. The court reduced it on other factors.
Yes, Lordship.
We'll apply this law. You marry, then we do it.
That is not my case, Lordship.
Marry. Otherwise, no. 15,000.
Yes, Lord.
And for the child? Nothing. Combined for both. Oh,
Both.
then means son 7,000, mother 8,000.
That has not been discussed, Lordship. All
You
along.
put in
the
some
order is-
evidence. You are saying tuition, bring some evidence before the court.
Lordship, certain liability that has not been considered, Lordship, that has not been looked into, because what I'm on is that it is the rule of this country, Lordship, after 2020, Lordship, after this Rajneesh and Neha judgment, both the parties in all cases, in 125, in Hindu Marriage Act, in this domestic violence maintenance, in this Hindu adoption and maintenance, in all proceedings, the parties are required to submit affection liability, and court is to look into, take into consideration
for determining the so-and-so. What I'm on is that in the impugn order, that has not been looked into, that has not been considered here. That is the illegality I have changed. What, your lordship may remand it for hearing, and after considering all these aspects, court may pass order.
But
That may
till,
be lawful.
till then, 15,000 happens.
Till then. Yes, lordship, till then I am paying.
Again, fine.
He has to clear
Till-
the arrears.
Till
Then
then
he
I
has
am
to clear
paying.
the arrears.
Till then I am paying.
There should be a condition, my lord, that in that case,
I have already paid.
your lordship is inclined, my lord, to remand it back. That case, my lord, he should clear the arrears because he's not paying the arrears regularly. That is my
Lordship,
instruction.
Lordship, I may submit, he may not have proper instruction. On 29/5/25, I have paid rupees 15,000. On 18/3/25, I have paid rupees 15,000. Earlier on February 14, I had paid rupees 10,000. On that month, I could not pay. But thereafter, I am paying rupees 15,000, Lordship.
No, fight it out there. What is there?
Yes, Lordship. Maybe.
Fight it out there. You know what to do if he doesn't pay. Instead of fighting out here. The petitioner herein have challenged, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so, who appears on behalf of the respondent. The present proceedings have been initiated challenging the judge order dated 3/2/2024 passed in Mize case number 48/2022, whereby the learned court of the district judge FTC Punitpur had directed the petitioner to pay maintenance pendant light at 15,000 per month to the petitioner from the date of filing of the petition until further orders, and also directed to pay 30,000 as cost of the proceedings. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that rupees 30,000, as which is the cost of the proceedings, have duly been paid. However, he submits that the amount of rupees 15,000 so arrived at as maintenance pendant light per month is a steep amount, taking into account that the petitioner's monthly income is just 33,000. 33,000.
Yes.
Full stop. He further submitted that in terms with the judgment of the Supreme Court in the case of Rajesh versus Neha,
Yes,
reported
that's
in, is it? I don't need to see it.
2021, 2 SCC, 324.
3 to 4, comma, the learned, both the parties having filed the assets and liabilities.
Yes.
The assets and liabilities, it was incumbent upon the learned court of the additional district judge FTC Punitpur to pass the order of maintenance pendant light after taking into consideration the same. He further submitted that a perusal of the order dated 3/2/2024 would show that there is no application of mine of the court below in respect to the affidavit of respective affidavits of so filed, except mentioning that both the parties have duly filed such assets and liabilities. Affidavit of assets and liabilities. Per contra, Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, respondent submitted that the petitioner herein that the amount of rupees 15,000 itself is a very less amount, taking into account that the said amount includes the care and needs of the child who is with the respondent. He further submitted that the respondent has no source of income, whereas the petitioner not only has income, but also has various lands and properties. Full stop. He therefore submitted there is no question of any interference. Full stop. This court have duly perused the order dated 3/2/2024, passed in Mizze case number 48 of 2022, as well as the respective affidavits so filed as pertaining to the assets and liabilities. Full stop. This court, though, this court have also perused the impugned order, wherein there is no reference to the there is no discussion in respect to the respective assets, respective affidavits of assets and liabilities. Considering the above, this court this court interferes with the order dated 3/2/2024 and there passed in Mizze case number 48 of 2022 and directs the learned court of the additional district judge FTC Hunitpur Tejpur to decide the said application afresh by looking into afresh on the basis of the respective affidavits of assets and liabilities. This court further directs the petitioner herein to file a fresh affidavit of assets and liabilities, both the parties to file fresh assets and liabilities, and also the latest income tax returns, if any, of both the parties. Full stop. This court further duly takes note of that the order dated 3/2/2000 by the order impugned order dated 3/2/2024, there was a direction of payment of an amount of rupees 15,000 per month as maintenance pendant light, as well as also a direction to pay 30% as cost of the proceedings, comma. This court makes it clear that the interference so made to the order dated 3/2/2024 shall not be deemed, shall not in any manner be construed as an interference insofar as the direction to pay rupees 30,000 as the cost of the proceedings. Further to that, taking into account that since 2024, the 3/2 February 2024, there was a direction to pay the maintenance pendant light at the rate of 15%, where 15,000 per month. This court directs the petitioner herein to continue to make such payment till the disposal of Mizze case number 48 of 2022, which is restored by the instant order. Accordingly, the instant petition stands disposed of with the following observations and directions. Number one, the order dated 3/2/2024 is interfered with, thereby directing the learned first appellate learned court of the so-and-so to decide afresh Mizze case number 48 of 2022. Number two, the interference so made by the order dated 3/2/2024 shall not be construed as interference insofar as the cost of rupees 30,000 awarded in favor of the respondent herein. Number three, this court This court further restores Mizze case number 48 of 2022 to the file of the so-and-so court. Number four, this court further directs that till the disposal of Mizze case number 48, this court further directs both the parties to file fresh affidavit of assets and liabilities, thereby bringing on record the latest income tax returns, if any. Number five, this court further directs the petitioner herein to continue to make payment of the amount of rupees 15,000 as decided by the order dated 3/2/2024 per month till the disposal of Ms. case number 48 of 2022. Number 6, this court, it is further directed that this court, that as both the parties are duly represented, that they shall appear before the learned court of the so and so on 14 July
5/7, Lordship, there's a
On-
date,
on-
fixed
on-
date 5/7.
5/7/2025. Full stop. The council appearing, the petitioner would be at liberty to file, the request the learned court for an early disposal of Ms. A case number 48 of 2022, which is being restored by the present proceedings.
All right.
The trial court shall independently decide.
Aye.
Trial court shall independently decide the
The
Ah,
quantum
one
law.
observation.
It is further observed that that this court had interfered with the order dated 3/2/2024 only on the ground that the learned court did not consider the respective assets and liabilities, the respective affidavit of assets and liabilities. Full stop. The full stop. Under such circumstances, the learned court of so and so shall decide the said application being Ms. A case number so and so afresh without being influenced by the order dated 3/2/2024 as well as the present proceeding.
Right.
See, go and fight out there again.
Sixteen,
Mr. Ghosh,
Lordship.
what is this?
This is a civil division petition, my lord, against reversal of the judgment, my lord.
Section
115 CPC, my, 115 CPC, my lord.
challenging what?
Alleging, my lord, against the judgment and order dated passed by the first appellate court, my lord.
Where?
Reversing the judgment of the trial court.
Huh?
Reversing the judgment of the trial court, my lord. It's a case under Assam Rent Control Act, my lord.
Oh,
Uh,
which ground?
My lord, both the trial court has, my lord, decreed the suit, both on the ground of defaulter as well as bona fide requirement.
The other one? Appellate court dismissed.
Appellate court has, my lord, they reversed the finding.
Oh.
That is why I'm.
Oh, you are the owner?
I'm the owner.
Okay. Ah. No, service is completed. Chalo. Records have come? No. I say. Okay. Why nobody is appearing?
No, my lord, despite my lord report, but I'm told that
Ah.
the respondent number 2 has received the notice for himself and 1 and 3 also. The town can hold that is the defaulter, my lord. There is no compliance with the section 5 subsection 4 of the Assam Urban and Control Act, my lord. So, and the Malayalam appellate court taken into consideration, my lord, matters beyond pleading, my lord. And reverse the finding.
Why? On the defaulter, what did he say?
My lord, on the defaulter, lordship, people, lordship, my lord, kindly look into page 94 is the finding of the trial court. To start-
Chalo, let them be there. Let us have it after vacation. What do you say? Let us do one thing, although
Right.
the service is complete, how have you affected service?
My lord, it is a
The
book,
notice was served upon the respondent number 2. Who is the respondent number 2?
respondent number 2 is the, my lord,
Huh?
who is the, my lord, son. Son of the.
The original defendant was Kirut Soikia.
He died, my lord, during the proceeding. He was
Indian-
substituted by the present
So
respondent.
their sons are there.
Yes,
We'll finish it up today some other day, today. After vacation, before vacation, we'll. Hello. How many matters are there on 19, 7? Hello, one matter we'll finish it up. Let's finish it up on 19th.
19 June.
19 June.
No.
We'll allow you. Is the matter on the, Mr. PJ Ghosh appears on behalf of the learned counsel appears on behalf of the petitioner. However, none has appeared on behalf of the respondent in spite of service being affected. Full stop. The records have also been received. Full stop. When did you file the suit?
My lord, the suit was filed in the year, my lord. 2016, my lord.
The learned counsel appearing on behalf of the petitioner submits that the present landlord dispute proceedings have been pending since 2015.
16, lord. Title suit, my
And
lord.
the dispute has been pending. Has been almost a decade old and therefore submitted that the matter requires an early disposal. So taking into account the above, list the matter on 19th of June 2025 at 2 p.m.
No. Offline, lord.
May I please, my lord? My lord, I have a small request, my lord. The assisting the assisting counsel is out of station. And he went to his local home for Annaprasana of his son. He is expected to come within 2-3 days. I therefore pray that it may be taken up after 2-3 days. As
That's
a fixed
okay.
item.
Your case is what?
It is
You are the
a-
landlord, landlord tenant.
Landlord.
You are the tenant. But,
After 2-3 days.
but how can I take up this matter at the admission, taking into account that it has already been admitted?
Yes, that is how.
List this matter for hearing in the usual course, liberty given to both the parties to file application for the records I sent.
In fact, in the order admitting the revision petition, there is a observation that attempt will be made to dispose. Or whatever it's
Okay.
2211 order.
Yes, they list the matter on so and so on that date and effort shall be made to dispose of. Understood, so
If a date. will
when
be
do you want then?
If a date, because the execution is stayed, that is the difficulty. The execution has been stayed.
How many courts?
2 courts concurrent against them.
Then also he got it admitted. He got a very good case.
It was
then.
not before your lordship, my lord, for
Huh?
that one. It was not before your lordship's court, that is what for it. My lord, as it is, they have no case at all. Since
We'll
2000
have it on, I don't know now. Okay, let's have it after vacation, any date.
And date can be fixed.
It is seen that by an order dated 22/11/2024, the learned coordinate bench of this court had already admitted the instant revision proceedings. So considering the above, the instant revision petition be listed for hearing. So it is also observed that an attempt shall be made to dispose of the said revision proceedings at an early date. Full stop. The records have also been received. Full stop. Accordingly, list the matter on when 15,
17,
22, 29, which one?
not 17 if possible.
Huh?
17 if possible.
17, if it is, I am sitting,
No,
I would
even-
not take up on 17.
No, 29. The 29.
20. July,
29, July.
July.
9
29 July.
July, I have some program, my lord, I may go out.
Okay.
If it is earlier to that, my lord.
22nd?
22nd, I have
Okay. So then
17.
any date convenient to your lordship if necessary after
17th of-
29.
5th of August? On 5th of August?
My lord, there. On 11th of August.
We finish it up before vacation. 24th of June at 2 p.m.
18,
Petition is agreed before your lordship against the impugned order, which is annexed here with this petition, annexer 3, my lord.
Where is that order?
Annexer 3, page 23 onwards. In this case, my lord, the respondent has, is getting dual maintenance.
How much given?
3,000 has been granted by way of interim maintenance, under the Domestic Violence Act by the Court of Learned JMFC Dorang. And on the other hand, in,
You're
TSD,
given 6,000.
3,000 as interim maintenance.
Huh?
As interim maintenance,
Who? By another court
yes.
and another 6,000.
Another 6,000 by the district court, wherein the divorce proceeding has been filed by herself against me.
But have they taken into consideration the 3,000?
Yes, taken into consideration, but nothing has been elaborately
where?
discussed. The lordship will find a cooperative portion at page 25, my lord.
Are both of you working?
She is also lawyer. I am a serviceman.
You're a lawyer?
Yes, ma'am.
I'm a lawyer, newcomer.
Huh?
Lordship, I'm a newcomer. I'm a junior advocate. My enrollment is last September 2023. I got my enrollment newly.
And you are an assistant sub-inspector?
Yes, madam.
Huh?
Yes, ma'am.
So what is your problem?
My difficulty is that before lordship, on
Also
the
for
point
an
of question of
interim
law.
Maintenance in connection with so-and-so, but area of maintenance has not been paid. Also, file an exhibit. Monthly income of imam.
Non-payment of, my lord, if dues any, that is the part of the adjudication of the learned trial court. They can raise objection for payment.
So,
far as latest
The question,
instruction,
Mr. Counsel, can I increase it?
my lord,
Can I increase it?
I have come before your lordship for some on question of law, not for increase, not for decrease here.
What do you want?
Because so far as the definition of section 25(4) of Hindu Marriage Act speaks that the provision contemplated for in the form of maintenance pendency life. To read the definition of maintenance pendency life, it is categorically divided in two parts. One is related to the maintenance to be awarded to the wife along with some legal proceedings, cost of legal proceedings. But here in this case, my lord, so far as legal proceedings, she is capable of to maintain herself for legal proceeding for which no extra expenses for to attend legal proceeding because she is the local person from there by born and brought up there. The second thing is that with regard to maintenance, she has not filed any maintenance petition before any court of law under section 125. So,
But
yeah,
she has filed this
she
petition.
has filed this petition under the enactment of Domestic Violence Act before another court.
No, this application, title suit D 35
It is the
is
case of
in
divorce.
respect to a petition under 24.
24. 25(4) is she will entitle maintenance whatever granted by the learned district judge till the disposal. If the said case is ESD 35 disposed of after 3 months, she will not be entitled for any maintenance after disposal of the petition. It is a temporary measure which has been enacted under section 24 of the Act. But so far as regular maintenance, she has not filed because to file regular maintenance, the opposite party has to wife have to be a person who is
totally unable to, for any income. And there are so many grounds why, in which manner the husband drove her, she has been living separately. There are so many issues, so which she cannot prove. Because no such any criminal case has been lost against me. She is willfully not residing with me and files the divorce case. Even so far as my instruction, my client is going to file a petition for restitution of conjugal rights.
Who has
by
filed
opposing
the divorce?
Divorce filed by my opposite party, my wife. Yes. Unnecessary. Even I am ready to take her back.
You have filed the divorce.
Yes.
So there you have filed the 24 application.
Yes. On the other hand, she has filed another DV Act.
So there they have got dates, huh?
So far as that is her wisdom to file any case against me at any forum as per law. But my humble submission before your lordship is that so far as the judgment of Rajneesh, provision number 128(1) and 128(3), if any maintenance to be awarded in favor of wife, that is to be not in multiple forum, that is to be in one forum.
A person who files a divorce application also can file.
Yes, I have not raised any objection. She can file.
Then
Being a
what is
wife.
wrong?
But wrong is that so far as the multiplicity of proceeding, if she had to obtain more maintenance fees required, she have to file appropriate application before the court of learned JMFC Dorong, wherein interim maintenance has been granted and final maintenance part is due. And if
No,
there
no,
are any
the
more
question
difficulties,
is
so
if-
far as my submission.
No, are you
Yes,
saying
Yes,
that during the pendency of the divorce case,
yes.
the district judge does not have the jurisdiction to pay, direct make payment to her?
What kind of payment, my lord?
No, does the district judge
Yes,
who is taking up the divorce case
Yes.
doesn't have the jurisdiction to make payment? And you say that the JMC and JMFC under 125 only has the jurisdiction.
no, this is the mandate of law as per decided by the Honorable Apex Court in this versus Neha. And prior to that, many other cases also.
Show me.
In Rajneesh versus Neha. In paragraph 128.1 and 128.3.
No, 128.3 does not say that, because 128.1 says that where successive claims for maintenance are made
Yes, ma'am.
by a party under different statutes,
Yes, exactly.
the court would consider an adjustment or set off of the amount awarded in the previous proceedings,
Yes,
while determining whether any further amount is to be awarded in the subsequent proceedings.
yes.
So in the DV Act, under the DV Act or whatever may be, she has got 3,000. Now that, in my opinion, the 3,000 has to be taken into account while awarding the said.
But that is not been discussed in this order, input order, my lord. How she is entitled for 6,000 and only that by considering the ratio of
income, this impugn order has been passed, my lord. And the opposite party has failed to disclose her assets and liabilities in a right and fair manner. She has not details anything in proper format.
You have not filed your assets and liabilities.
Already filed it. Already filed it.
You filed it there.
Filed it.
Then
But that is not in proper, my lord. In support of our assets and liabilities, no documents have been annexed. Merely, I can lie anything in my disclosure and affidavit, but in support of averment and contention, that must be proved by you have any documented evidence, which has not been done in this case, my lord.
but the amount which have been awarded is too less.
I am not before a lordship any less or more. Herein, we have agreed
No,
before. a
no,
lordship.
I am on there.
People
because
approaches the honorable
Here
High
the
Court
court is
against the
exercising,
quantum.
but Mr. Counsel, the court is exercising 227. When you are earning 57,000 or what is that? 69,000.
No, we have not approached your lordship against 57 or 60 against. We
You are
have not
approaching
approached
this
before
court,
lordship
why?
for any, against any quantum. We have approached before lordship against the multiplicity of proceeding. Today, she has filed in the domestic violence. Tomorrow, she will file against 125 by making some vague pleadings. So to restrain this type of proceedings and to avoid multiplicity of proceeding, Honorable Appeals Court in this case, what I have relied before lordship.
So you mean to say
provided
that
such
if
type of-
she wants for enhancement from here
Yes,
or anything, she will have to ask for modification of this
or
order.
variation before the court, where first instance, Honorable Learned Trial Court granted, which has been 22 order. Which was in the year 22, 16 July 22.
So
Lordship,
you say that the second proceedings is not maintainable.
I am not saying the second proceeding is maintainable, but that aspect must have to be taken into consideration, which is no way mentioned in this order while passing. The opposite party is entitled for maintenance because the district judge forum is the upper forum than JMFC. So, London district judge ought to have taken his observation by recording that she is entitled for maintenance by of so and so, whatever it may be, by the London JMFC Doral. In addition
You
to
mean
that,
to say when
in
the
addition to
learned
that-
district judge passed the order
on
while
the,
awarding 6,000,
Ah.
the learned district judge should have said
yes,
that in addition to this, although
She's
she
entitled-
should have been entitled to 9,000,
yes,
but we are setting up this 3,000
yes,
and as such we are giving her 6,000.
yes.
You said the order should be in that
yes,
manner.
Yes, like that.
Chalo, I make it clear. Over. You want that, I make it clear for
No,
you.
my lord. Only thing is so far as the.
And
Honorable
give her
Appeals-
opportunity to file. If she wants to ask for further, go before the district judge. Matter over. Only that,
Then what about the proceeding when domestic? violence is
that,
taken?
okay, now district judge will look over it.
She can, if this honorable.
But
court
then
allows-
also my question is, the district judge has given very less.
here
So
it is
I
neither
should
the opposite
therefore
party raising
say,
objection.
I should therefore say that 9,000, the district judge actually thought, set up 3,000, made it 6,000. But in my opinion, it is 15,000. So district judge set up 3,000, you pay 9,000 and increase it.
I not understood. it.
I'm on that. Because the amount is too less. Let us, in the, just a few minutes ago,
I have
there
not-
was, no, Mr. Counsel, there are a few minutes ago, there was another counsel placing before me, another judgment in the case of Koilan De Chaudhary. There, the court says, minimum 25% is to be given,
But
and this is
that-
salaried.
That part will come when the finally awarded any.
No,
matter.
no. This is for interim maintenance. So
No,
I
interim-
apply this
No,
25%
interim- my lord,
and
domestic-
then give you out of 69,000,
No, my lord.
25% how much? We do it. And direct them to pay you.
No, my lord.
Yes.
No, kindly
Okay.
lordship my hearing
No.
on this point,
Enough.
because it is a form of permanent, not a
Mr.
form of permanent,
Counsel,
my lord.
And pay her further cost for filing, appearing today, no? She had to engage somebody.
No, it is not in my pleading, my lord.
And not
issue-
necessary, 227, when you exercise, these are the big problem. Don't think this is a regular appeal.
In any proceeding, my lord,
No,
which is
let
not
us
read
now
before your
extend
lordship,
it.
how
Heard
can you
Mr.
lordship will go beyond
No,
that?
no, no, this is too less.
That is
I'm
not. been-
shocked because just now there was another council showing me another judgment.
No, that is.
So
the
apply
part-
that judgment. No, no,
No,
no.
I am not.
This
on
is
that,
too
my lord.
less. Okay, heard Mr. Name?
Paul,
A. Bora.
Paul.
A. Paul, the learned counsel appearing on behalf of the petitioner. And
H. Thakuria.
A. Thakuria.
H.
H. Thakuria, the learned counsel appearing on behalf of the respondent. Full stop. The supervisory jurisdiction of this court had been invoked to challenge an order dated 1/6/2024, passed in an application under Section 24 of the Hindu Marriage Act, arising out of Title Suit B 35/2022.
My lord, can I interrupt the meeting?
Huh?
Because your lordship has just only taken into account my salary. Your lordship has not considered my expenditure. What, 69,000?
You should know how much it is, but then also Supreme Court says 25%.
25% from the, not
And
from the,
also-
there is expenditure also. When
Mr.
the-
Counsel, here also the Supreme Court has categorically
you
said,
lordship to.
no, no.
Follow the LCR also, my lord. In LCR, your lordship will find the assets and liabilities properly.
Not, that is okay, but here the Supreme Court says
no,
that. This
If
is also same
if
judges.
Suppose I earn 30,000 per month, there must have to be savings, there must to be some, my monthly expenditure also, that is to be taken into account. Not only on the basis of my net income, it to be awarded to the other side, my lord. My expenditure, 16,000 loan is there in respect of a vehicle, my lord.
Sell the vehicle. Sell the vehicle because you should not have a vehicle. And obviously you have an official vehicle. You don't need so many vehicles. Assistant
cannot-
Inspector.
Official vehicle can be-
Mr. Counsel, first and foremost, you are a police officer. Then are you to tell me what is how it works? I don't need to say we are on live streaming much. He's earning so much.
I am
I'm
not-
increasing it.
I am not in road
No.
duty, my lord.
Mister, I can only give you one thing. You may withdraw. Nothing more than that. But otherwise, if I am to say anything, I'm passing an order, I'll ask them to increase. And then go to Supreme
Lordship,
Court.
then withdraw, my lord.
Withdraw. The petitioner submits that he would like to withdraw the instant petition for the immediate instance. So and so appears on behalf of the respondent.
Lordship, may I please? Lordship, they don't pay regularly pay, can pass order that they can pass.
Submits that he, submits that he would like to withdraw the instant.
Only 35 till.
Ms. So and so appears on behalf of the respondent and submits that the petitioner, though have challenged the order but have not regularly made the payment. Full stop. Taking into account that the petitioner wants to withdraw, comma, the instant proceeding stands closed, comma. The learned, full stop. This court observes that in the if the petitioner had not made any payment, the liberty would be given to the respondents to, liberty is always there with the respondents to approach the court of the district judge, which court?
Dorong.
This is the learned district judge Dorong Mongoldoi, complaining about the non-compliance to the order dated 1/6/2024 and initiate further proceedings.
19,
Yes.
On previous day 19/5/2025, Lordship directed to the petitioner to file a bring on record of the monthly maintenance, Lordship. Today itself filed a affidavit.
File an affidavit.
Yes.
Where's the other side?
I
Survey?
mean, not a pair, sir. Already the service completed.
Okay. Mr. K.R. Bora appearing on behalf of the petitioner submits an affidavit has been filed
On today,
pursuant to the order
dated 19/5.
dated 19/5/2025 today. Today. Full stop. Accordingly, lists this matter on 21st of July 2025 comma, the interim order passed earlier shall continue till then. The registry shall bring on record the said affidavit.
20,
Yes, what is this? What are you challenging?
Lordship, I was not served with a complete set of plain clothes.
For filing of the written statement and its complete set of Where's the other side? Service
Service has been completed, Lordship.
completed.
AD, and in Dusty Lordship, they refused to read the copy.
Yeah, A4.
Some typographical mistake was there, Lordship, in the regarding one word, Lordship. Plaintiff is written in the petition, Lordship. It should be petitioner, Lordship, in page number 5. And one date, Lordship, it is, I have written it as 29/9/2024. It should be 30/9/2024, Lordship.
I4. This is an application file seeking certain correction to the accompanying petition, wherein there appears to be certain typographical errors. The learned counsel for the petitioner submits that at page 5, para 4, row number 4 and 5 of the accompanying petition, the date has been mentioned as 30/9/2024, which should have been 29/9/2024. And at page 5, para 4, row number 5 of the accompanying petition, the word plaintiff has been mentioned, which should have been mentioned as petitioners. To stop taking into account that the said mistakes are typographical errors, comma, the same are the petitioner is directed to the instant application stands allowed, thereby permitting the petitioner to make necessary correction to the said petition by to the accompanying petition by hand with the signature, with an initial being put by the counsel appearing on behalf of the petitioner. I stands allowed. Econo Deva, list the matter. We wanted to finish it off.
Lordship, one page of the claims was not served on me, Lordship. That's why I could not find out there.
Oh, this one. Like to submit before your honor that the courts were closed for the moment. We do one thing, we allow it. But I've asked you to make correction.
Yes, I'll make it, Lordship.
Chala. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. 25,000,
They are very poor persons.
no small person, big person. Did not file your written statement, how can I help you? Didn't I tell you on that day, when I allowed you a notice, 25,000? Heard Mr. N.K. Kolta, the learned counsel appearing, N. Kolta, the learned counsel appearing on behalf of the petitioner. Full stop. The petitioner, by way of the present proceedings, have assailed the order dated 2012-2024, by which the petitioners,
Petitioners, Lordship. Two.
the petitioners were
Son and
not permitted to. Who you are paying for? Petitioners who were the defendant numbers?
1 and 2, Lordship. They are the defendants.
1 and 2. There's no 2. Huh? What is this type of suit? Defendant numbers 1 and 2 in the suit,
Yes, Lordship.
isn't it? Defendant numbers 1 and 2 on the suit were debarred from filing the written statement on the ground that the summons were served on the defendants on 21/9/2024 and "90 days was over on 20/12/2024. Full stop. Full stop. This court. Full stop. It is the case of the petitioner herein that the that on account of non-receipt of a page number 8 of the plaint, comma, the written statement could not be filed for which an application was filed. But the learned trial court did not consider the same, but rather debarred the petitioners who are the defendants in the suit from filing the written statement. Mr. N. Kolita, the learned counsel appearing on behalf of the petitioner, submits that the written statement is ready, is it? And can be filed on any such date as this court may direct. So taking into account the above, it is also seen that in spite of service being meted out upon the respondents, it is also seen that the respondents have not cared to appear or have received the dusty service.
Actually, WS is not ready, Lordship, because I'm not getting the complete set of plaintiffs.
Mr. Counsel, as of now, you have the page number 8.
No, Lordship. Yet to be served on me, Lordship.
Huh? Mr. Counsel, you get your, as of, it is not a problem to get a certified copy. Don't come up with this type of excuses before me. So you file your WS on that date, along with the cost. As of now, this is an excuse I am making it for the purpose of giving you the relief, nothing more than that. You also know, and don't think that I have only come and practice out there in the High Court. I was predominantly a civil lawyer, so I know what the lawyers do. So you must be knowing out there. Asking for one page is not eligible. This is how you seek for more time, and thereby getting more and more dates. It is also seen that the respondents steps were taken to serve upon the respondents herein who were the plaintiffs copies of the notices, copies of the summons, copies of the instant application through Dusty, but the respondents have not accepted, for which an affidavit of service have also been filed before this court. I've heard this court have duly taken note of the order dated 2012-2024 and taking into account the ground which have been taken by the petitioners who are the defendants in the suit, it is the opinion of this court that the learned trial court ought to have permitted the filing of the written statement by a day or so, by extending the period rather than debarring the defendants from filing the written statement. Accordingly, this court for the ends of justice permits the this court further takes note of the submissions so made by Mr. N. Kolita that the written statement is ready and can be filed on such date as this court made so direct. Accordingly, this court interferes with the order dated 2012-2024 and permits the petitioner, who are the defendants in the suit, to file the written statement. This court also takes note of that the fact that the page number 8 was not available in the plaint was not a ground taken earlier when the defendants have appeared in the suit. And this clearly shows certain amount of negligence and lack of due diligence on the part of the petitioners oblique the defendants. Under such circumstances, it is also the opinion of this court that the plaintiff has to be restituted on the ground of such negligence, for which this court is of the opinion that an amount of 15,000 would be adequate, would be reasonable. Considering the above, this court therefore disposes of the instant proceedings with the following observations and directions. Number one, the order dated 2012-2024 passed in title suit number 143/2024 is interfered with. Number two, this court permits the petitioner herein who are the defendants in the suit to file their written statement the next so dates fixed herein under, along with next, this court imposes a cost of rupees 15,000 upon the petitioners oblique the defendants, and the same amounts has to be deposited before the learned trial court along with filing of the written statement. Full stop. Acceptance of the written statement for the purpose of the deposit of rupees 15,000 shall be a condition precedent for acceptance of the written statement. Number 5. This court by an order dated 34/2025 had stayed the further proceedings of title suit number 143/2024. Fusa. The said stay order stands vacated, comma. The petitioner is directed to appear before the learned trial court on
Next date fixed on 25/7, Lordship, in the trial.
on 25/7/2025, on which date the petitioner shall file their written statement without fail on that date, along with and deposit the cost of rupees 15,000. With the above, the instant proceedings.
21.
Ground.
Quantum as well as involvement of vehicle. A 17-year-old boy, Lordship, 21 point, almost 22 lakh 7 awarded, Lordship, by taking the income as 13,000.
And the other is?
See, the company had given evidence that immediate GD entries did not, there's no mention of this particular vehicle. There's some unknown vehicle had done it subsequently also without any explanation. And Lordship, even,
On what basis does the the tribunal come to a finding?
Lordship, on the basis that shows the para 40, Lordship. Para 40. Evidence has been discussed in para 36.
Now, why does it say that that was the vehicle? Pursuant to mention that the owner and the driver had not
Mangalaram.
contested the suit, the insurance company had not appeared before the tribunal to prove that the accident did not occur. Have not, insurance company has not appeared? Paragraph 38?
Evidence.
To prove that the accident did not occur involving AR due to
Owner
the
and
AR.
driver.
No, kindly see the
Oh,
next
yes,
one.
Lordship, this is wrong, sir.
The insurance company has utterly failed to prove on record that the accident in question was not caused by honorary man. And so, and that it is sufficient to prove the fact of the accident, and if the claim petition submitted by a fire. If the claim petitioner submitted the FIR of the accident, the death report and so on. So all these things were given, FIR of the accident.
Lordship, even in fact, the claimant there, MBI report was also there of the vehicle, Lordship, Wagoner. Lordship, the claimant stated after saying that there's not a scratch on the wagon. All this leads to the belief that this may have been implanted. If it was not there.
In the
That
present
question
case,
has put
FIR has
problem.
been lodged, case has been registered against the driver of the offending vehicle bearing registration number so and so, and after completion, investigation has charged it. The driver has not challenged the charge sheet. Submission of charge sheet against the driver of an offending vehicle can be considered sufficient evidence.
That
so
is
and
the
so.
main ground.
So maybe, but we direct
If,
50.
I'll not pay deposit lordship, let
50.
come for release of that.
No, release here only, no more.
See,
I'm
the
satisfied.
involvement is the.
No, Mr. Goswami, involvement is satisfied with the charge sheet, although I'll put it as a ground, but the involvement is satisfied. Only on the quantum. Quantum is how much?
Quantum is 21.98 lakhs.
How much has been the age been taken? It's 17 years.
17. 50% loss,
21 lakhs.
21.98%, almost 22 lakhs.
Along with 9%. He just writes his orders something differently, na? Very complicated manner. Interest on future prospects given.
Yes, lordship.
Hmm?
Yes, lordship.
So per month it has been taken how much?
13,704. I'll just check.
How much it should be? As per you?
That one considers for average lordship persons,
He was not working.
17-year-old, a school student.
So why 13,000 has been arrived?
Minimum wage is lordship for the.
Minimum wage now is
That is for
13,000.
a skilled person, lordship, we could, if it was unskilled, that is also something.
This case, Meena Paula was a case of engineering institute.
Yes.
And here, what is he studying? Class 10.
That's 10 lordship.
So what should be the minimum wages? He would get the minimum wages of 9,000. 9,000 is the amount. Huh? We take it up next Wednesday, today, Monday, Tuesday, Monday or Tuesday, Wednesday. You just come up with 9,000, what it should be. Because if a person is not working, then you, and I was proved, there cannot be a question of skill or unskill. We can be taken as the unskill. And then we direct you to pay that amount. And then you see, only concern is if unnecessary on question of interest, why should we go to? So if that 9,000 is being taken, that is the amount. So I direct them to deposit in the registry in that tribunal and then apply that.
Should apply minimum wages for people who are in the working range, lordship, who are eligible for work. But when we come to children, should also be this, I have seen this happening, even for children, minimum wages being applied. There should be some
good yardstick for students what should be. Minimum wage is someone who is of the range of 20 plus, who can also work, earn and make a living. But for student, it will be, it should be correct.
So children,
sure
how
the
how do you judge then if a
Yes, so
child
that-
dies? Think about it, what to do. Huh? I will leave the matter on next meeting.
Alright.
The children,
Supplementary item 40.
ground,
Well, on the last occasion, Lordship had directed me to get the information about the amount of family pension. So this claimants used to get because the person, the deceased was a pension holder. And after his death, the claimants were receiving family pension. Now I have written to the this insurance company. They have sought for 10 days time to get the NHR 5 and 6. These are documents.
and if they are getting the family pension,
Yes,
that family pension has to be set off.
from the pension.
No, from the award.
Yes, yes. That's right.
In my opinion, what is required to be done is you do as it is. Pension amount, you do as it is, apply everything. Then you set up that
Yes.
family pension part and then come up with how much. Mr. Evachaji submits that he requires some more time to obtain instruction as regards the amount of family pension the claimants are now entitled. The drawing was drawing at the time when the accident took place, which is there in the records. To stop, this the matter again on 23rd June.
Obliged.
Item 22, hearing under order 41 rule 11.
Yes.
So in this case, Lord,
There is a written statement. Written statement,
68 claim, right?
page.
68.
This is one. This is the plain. Written statement is where?
Written statement is 68 page.
This is a suit. Page 57. 58 is the suit.
No, 68.
68. You don't accept that the plaintiff is the owner. That is your stand in the written statement. Where is the question of adverse possession?
The paragraph 13, Lord.
That is what I've seen.
Hmm.
You categorically say,
But
but it
the
is
plaintiff
denied
for 35
that
years
so
not-
and so sold the suit land to the plaintiff by registered sale with delivery of possession. Meaning thereby, you don't agree.
Thereafter, in the subsequent line.
Huh.
Yeah.
For the last year was
Plaintiff-
not in
plaintiff for
possession
last
of the
5 years was
plaintiff,
not
even
in
if he has
possession,
purchased and as such
even
claim
if-
the title has extinguished. It cannot extinguish.
Then after suit the land, claimed the title already.
It cannot extinguish. Merely possessing it is there. You have to deny the title of the plaintiff. You have to accept the title. That yes, the plaintiff was there. You have to get it. No case. So what to do? Dismiss. B is 27 does not have any relevance out there. One A and B are one and the same. Both courts against you.
Yes.
Obvious. If this defense is taking.
2006 title suit. 2006 title suit, my lord.
I think the well deed was executed in the year 1972. But at that time.
Let it be executed in 1872. But then also, hardly matters. He continues to have title unless you are adverse, there has to be a hostile possession. And that to adverse to the true owner. The pleadings out there, there's no pleadings. And without the pleading, there's no evidence. Let me now today make it a very short order today. Heard Mr. Edas Gupta, the learned counsel, appearing on behalf of the senior counsel assisted by so and so, appearing on behalf of the appellant and Mr.
H. Das.
Why are you appearing? You are on caveat.
Yes, ma'am.
Mr. H. Das, who appears on behalf of the respondents.
All.
Full stop. The present appeal has been filed under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 19/9/2024 passed by the learned District Judge Bongaigaon entitled Appeal number 02/2015, thereby affirming the judgment and decree dated 31/7/2015 passed entitled suit number 27/2006. Passed by the learned civil judge Bongaigaon, hereinafter referred to as the learned trial court, whereby the suit of the plaintiff was decreed. Full stop. The instant appeal is being taken up at the stage of Order 41, Rule 11, to ascertain whether any substantial question of law can be formulated in terms with Section 100(4) of the Code. Full stop. Mr. A. Das Gupta, the learned senior counsel, appearing on behalf of the appellant, has proposed that the proposed two questions of law, which are mentioned in the memorandum of appeal as A and B, and submitted that the said two questions of law be formulated as substantial questions of law in the present appeal. Full stop. The question arises, therefore, full stop, the said two questions of law so proposed are reproduced herein under A and B, page 403. The question which arises in the instant appeal is as to whether the said two questions of law can at all be formulated as substantial, the question which is being taken up for consideration by this court at this stage is as to whether the two questions so proposed can be at all formulated as substantial questions of law in the instant appeal. Full stop. On behalf of the full stop. In order to ascertain the same, comma, this court finds it relevant to take note of the brief facts which led to the filing of the instant appeal. Full stop. For the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. Full stop. The respondents herein had filed a suit being titled suit number 27/2006 before the learned court of the civil judge, Bongaigaon. Seeking declaration of right title and interest over the suit land for recovery of caste possession and for permanent injunction. The brief facts which led to the filing of the suit is that the plaintiffs, one plaintiff over how many plaintiffs? One plaintiff. Now the respondents are the successor in interest.
Yes.
এনেকে লাগিব এইটোৱে হ'ব seen that the predecessor in interest of the respondents in the instant appeal have filed a suit being titled suit number 27/2006 before the court of the civil judge Bongaigaon, seeking declaration of right title and interest, comma, recovery of caste possession as well as for permanent injunction in respect to us. The case of the plaintiffs is that a plot of land at measuring 0 bigha 2 katha 18 lechas, covered by Khotian number 66, Dag number 599, and present Miadi number and Miadi Patta number 36, old 39 new, Dag number 599/5983, old, oblique 195 new, situated at village Dolaigaon, part 2, circle Bongaigaon in the district of Bongaigaon, was purchased by the plaintiff by the deed of sale bearing deed dated 3/10/1972. It is the further case of the plaintiff that the said that after purchase the plaintiff was delivered the possession. And the petition and the plaintiff thereupon mutated his name in the revenue records and paid the land revenue. The plaintiff also stated that he had constructed a well-marked boundary having pillar and brick wall. It is the further case of the plaintiff that the plaintiff had been working as a cashier in the State Bank of India, Gwalpara, since long back, for which he had to reside at Gwalpara with his family, and he occasionally used to visit the Sut land. Upon his retirement from service, when he intended to settle up at Bongaigaon by constructing a dwelling house over his Sut land and for the development of the land, the defendants, who having no right, title, and interest over the Sut land, interfered with the possession of the petitioner, plaintiff, and encroached the Sut land in the month of January 2006. Thereupon, the plaintiff filed the said suit seeking for the reliefs as above stated. The defendants filed a written statement. In the written statement, the defendants categorically denied that the plaintiff had purchased the suit land from late Mohendra Roy. Further to that, it was the specific case of the defendants, as would be seen in paragraph number 13 and 14, that the plaintiffs, after having the plaintiffs, even if have purchased the suit land 34 years ago, but was specifically that the plaintiffs for the last 34 years was not in possession of the suit land. And even if the plaintiff had purchased the suit land, the said title had already extinguished under section 27 of the Limitation Act. It is seen that on the basis of the pleadings, the learned trial court framed as many as 12 issues, which being relevant are reproduced herein under page 43. On behalf of the plaintiff, 3 witnesses were examined and various documents were exhibited. On behalf of the defendant, 3 witnesses were examined, but no documents were exhibited. The learned trial court, after passed the judgment and decree, thereby decreeing the suit in favor of the plaintiff, and thereby and further holding that the suit was not barred by limitation and hit by the provisions of section 27 of the Limitation Act. While deciding the issue number 6, it was observed, the learned trial court duly observed that the plaintiff had duly purchased the suit land from late Mohendra Chandra Roy on 3/10/1972 by executing a registered seal deed. On the basis of the findings so arrived at, the learned trial court had decreed the suit. Petitioner, the plaintiff, the defendants being agreed, preferred an appeal before the court of the learned district judge Bongaigaon, which was registered and numbered as title appeal number 2/2015. And the said appeal was dismissed by an order date, judgment and order dated 19/9/2024. And it is under such circumstances the present appeal has been filed. In the backdrop of the above, the question arises as to whether the 2 questions of law so proposed can at all be framed as substantial questions of law. This court have duly perused the above quoted proposed questions of law, and in the opinion of the same, the said 2 proposed questions of law are one and the same, which relates to as to whether the defendants have been able to prove adverse possession over the suit land on the basis that the plaintiff, even after purchasing the suit land on 3/10/1972, did not institute any suit proceedings till 2006. First, it is well settled principle of law that when adverse possession is claimed, there's a requirement. It is well settled proposition of law that if the defendant claims adverse possession, if a party claims adverse possession, such claim of adverse possession has to be against the true owner. In the instant case, the defendants do not even admit that the plaintiff is the owner of the suit land. And as such, the question of claiming adverse possession is totally misconceived. Full stop. The court further finds it also relevant to mention that there are three ingredients for claiming adverse possession, which are, what are those, Mr. Das? Three ingredients, what?
Matlab they are,
If you don't know, I'll strike out your name that you appeared. Then why are you appearing? Tell me, give us a good reason.
three conditions are there, my lord.
What are these?
But
Just standing here. Mr. Ghosh, what is that? The three conditions?
2019 8 SCC 729.
What are these? I believe judgment are given. Renege. These are three conditions.
probably
2019. It is well settled that for a person to claim title by a person to claim adverse possession, he has to prove three aspects, three necks: nec vi, nec clem, and nec picaro. In other words, he must show that his possession is adequate in publicity, continuity in publicity, and in extent. Full stop. It is also settled that full stop. There is not a single pleadings in the there's not a pleadings in the written statement in respect to the three ingredients for the purpose of proving adverse possession. Full stop. Considering the above, it is therefore the opinion of this court that the questions of law which have been proposed cannot be framed as substantial questions of law in the instant appeal. Accordingly, as there are no substantial question of law that can be framed in the instant proceed, the instant appeal cannot be proceeded, for which the appeal stands dismissed. Post of taking into account the facts of the case, taking into account that the appeal is being taken up, is being disposed of at the stage of Order 41, Rule 11, this court is not inclined to impose any cost.
23.
Here in this case, it is a concurrent, but non-consideration of Exhibit 2, on the basis of which, my lord, it can be held that this property, after partition among all sharers, 5 sharers, this property falls in the share of the plaintiff, and defendant encroaches upon this land. He also one of the sharer. So suit filed for recovery of possession, and appearing in the suit, defendant claimed that this particular suit land, in exchange with the plaintiff, he got, and that exchange has not been proved. But in spite of that, both the court below held that I have failed to prove the title, absolute title over the suit land.
You got it by exchange?
No.
You got it by family partition?
Family partition. And defendant claiming that he got this suit land by exchange.
You are a
with me.
plaintiff?
I am the plaintiff.
So?
By way of family partition, among the 5 brothers, I got this land. In the Chitha Exhibit 2, there was a correction also in my name. Defendant appear and saying that, no, this land has been exchanged with me by the plaintiff. So I am possessing this suit land on exchange with the plaintiff.
Then,
And that exchange has not been proved by the defendant.
so
So title, there is no dispute with regard to title.
that you have title.
I have title.
Then,
Court below held that all the legal heirs has not made party. That another one is that the suit, I have no absolute title over the suit property. These two find.
and why none of these have any relation with the substantial questions of law?
Substantial question of law, my lord, C.
What?
Whether the
Holding
land
that the plaintiff failed to prove the title over the suit land without considering exhibit 2 from where it is clear after partition, the same falls in the share of the plaintiff as the property which was inherited from Fazal Ali. Whether the learned erred in dismissing the suit on the ground of non-joinder of necessary party that all legal heirs of though the suit is basically for encroachment of the land of the plaintiff by so and so. Did they raise the issue of non-joinder?
Yes,
Then
said that all the legal heirs are not.
and why didn't you make them party?
I have not made party. It is between the plaintiff and the defendant number 1.
Who are you?
I am the plaintiff,
That is why didn't you make a party?
defendant.
Didn't they raise the issue of non-joinder?
It in the written statement, one line has been given.
Then,
And there was no collision that,
where is the written statement?
written statement, kindly see, my lord. At page number 21.
Hmm.
Operative paragraph, kindly see 14, 11 and 14. 14 is important.
Verbal partition. Verbal partition,
That was not dispute.
but not dispute.
Yes, partition was not dispute.
You say that it is a verbal partition by
Partition in the
which
year
you have
1980.
acquired title over that land.
Yes,
And thereupon, where is the question of exchange? He says that you exchanged.
yes. I exchanged with him,
So you say that there was no exchange
no exchange.
because the exchange will require deed.
Yes,
But whether that the defendant was your brother or anybody,
yes.
hey,
One of the,
then how can you
Yeah.
have it when it's a question of verbal partition without the other
No, no.
parties?
verbal partition is not dispute.
Then,
After verbal partition, he said that since I have another 2 kathas of land,
Hmm.
which I have given to the defendant and
Hmm.
plaintiff, in
Hmm.
exchange, I got 1 kathas of land.
where is your written statement?
Not their written statement, page 14,
Page?
page 22, paragraph 14. That in reply to the statement made in paragraph 10 and 11,
Plaintiff right title and interest over the suit land as described fully. Did you lay? So what is your title?
exhibit 2,
Over schedule A on the basis of,
exhibit 2, I have produced.
what is exhibit 2?
Exhibit 2, the chitha and mutation which is in the name of the plaintiff.
How is it possible?
Because it was inherited property.
So without the others being made a party?
Others, there is no dispute. Here only 2 kathas 6 lesses of land in question.
How much did Fazal Ali had?
Was, it was
You have nothing to do with Fazal Ali, you are Kurban Ali. son.
nothing to do.
Then-
There are more land about 16 bighas and odd. 16 bigha, 4 kathas 6 lesser. Dispute only with respect to 2 kathas 6 lesser.
Acquired suit land by way of inheritance from his father. So your father's name was also there.
It was earlier. After partition, after death, in the year 87, all the name of all the sharers came. And all of them are amicably partitioned to their respective part.
Chalo. We have it on some other day. Very complicated. Where is the written statement? That is what I'm looking.
Page 21, my lord.
Page
21. One paragraph is clear, my lord. Paragraph 14, page 22.
Let's see the findings. Issue framed.
Issue findings, appellate court findings, page 64 and 65.
Where is the issue framed? Non-joiner party? Trial court decreed in your favor? Both courts. Then, where is the issue framed?
Issue, my lord, kindly see at trial court judgment.
No
30
issue.
34. 32,
Where is the issue on
33, kindly see.
whether the suit is maintainable? But there has to be a specific issue, isn't it?
No issue.
Chalo. Let's have it on. When is the? Huh? On Monday?
Monday, it will be.
খালি কোর্ট আছে নাই কোর্ট
No,
নহয় অফিস
Vacation. Vacation.
নাই অফিস আছে নাই অফিস ওকে when is the list the matter on when is এই ফাইলটো মোক পঠিয়াই দিবা হা মই এইটো অকন হালধীয়া এটা লগাই দিম এবাৰ চাই লম
Much more.
I think you have an issue as regards the substance as regards non-joiner if it is dismissed on the ground on non-joiner.
One non-gender, another is I have failed to prove the absolute title of a
Chalo, we'll see.
Much.
Stay matters, item 29.
Kita আছে ঠিক এটা What is this? Transfer.
Yes, sir, transfer from.
Transfer from where to where?
It is from Hojai district to Bongaigaon district.
Hojai to Bangagaon.
Yes, sir.
Respondent is a medical practitioner married to the petitioner. What do you do?
Lordship, I am petitioner, I am a housewife, Lordship. I am a housewife. Yes.
Madam, housewife?
My lord, I have already filed an
Yes,
additional affidavit. Two documents have been annexed to it. To prove that she has income. She is not a poor lady.
Yes, Lordship, I am coming there from Lordship to play.
What this Luit? Saloon is yours?
No, Lordship, it is their statement
My
only
lord,
there.
kindly,
Yes, I'm coming, Lordship. They have taken the photograph of my residence.
My lord, no.
I'm coming.
This is your residence?
Yes, this belongs to my father, Lordship. My father, where I am staying, I have no income.
My lord, kindly see the two in the signboard, my lord.
Yes.
Kindly see two phone numbers are there, my lord. One belongs to the petitioner, my lord.
Yes.
This is not only a saloon, this is an academy where trainings are also part.
Wait. Nowadays they have to file the petitioner's phone number here, na?
Yes, my lord. Kindly see in the their reply, my lord. Phone number is there.
The petitioner's phone number.
Yes, sir.
Yes, in his, my lord, reply, my lord.
Yes, possible.
Yes, 40, my lord.
How is it possible?
Page 40 of my reply, Lordship. I'm clear.
Petitioner, where is the form?
Page
You
40 of
fill up
my.
a form, na?
Yes, affidavit reply, page 40, Lordship.
Huh? How many? Where?
My lord, kindly see annexer 6, page 46. my lord.
এখন যে ফর্মখন আছে এখন কিয় fill up নাই কৰা? Why no phone numbers of these people are being given? Let us see the affidavit profile. How is this petition maintainable? The affidavit is not in terms with the High Court's order. The affidavit has to say that my phone number is this. The affidavit. This affidavit is not in accordance. We dismiss your petition on that ground. There is nothing mentioned. I call the registry shall, we have, there's a amendment to the High Court rules. We dismiss your petition on that ground.
But in the reply lordship, affidavit, no, reply lordship, I have mentioned the phone number page 40.
Huh?
Reply lordship, that is.
I am not on the reply. How is this petition at all permissible? All the filing superintendent. We'll take it up after some. All the superintendent. How is this? This type of, yeah, you have to mention it categorically in your affidavit. What is your phone number and all? It is not there. Yeah. What is it? Sangeeta Das. Kindly see. This phone number is 600-258812. Yes. Kindly see your affidavit in reply.
Yes. Phone number is-
You have given this phone number.
Yes, sir.
Then? That means it is you. But you are saying that you don't have. Your
Yes,
phone
sir.
number is giving
Yes,
you.
sir, I'm clarifying. There is two phone numbers. So for the.
One-
Yes.
One is a
The
sister.
Sister lordship,
And
these,
first one is her, my lord.
lordship, this is belongs to my sister. My sister not staying there. Sometimes she is coming or not coming. So it is our residence. So I am sometimes receive the phone number. If lordship permit me, I can bring the trade license also.
She is running, my lord.
Lordship,
She is
this is their
running
statement.
the,
If
my
lordship
lord,
don't
parlor,
believe
my
me,
lord.
I can bring the trade license lordship. That may
No,
be
no, my lord.
permitted lordship.
Statement not
That's
necessary,
lordship.
my lord, to
It is by
run up, my
taking
lord.
photograph cannot be that it is belongs to me lordship. Only the issue. And in two cases, he is coming from Ujjayi and appearing regularly lordship. I am staying lordship. Taking the photograph of the saloon lordship, that cannot establish I am earning
Yes,
lordship.
yes,
Let
my
me
lord,
allow
it
to.
is established, my lord.
Yes, this cannot be. Let me allow to bring the trade license lordship. It is
Trade
belongs
license
to my
not
sister.
necessary, my lord, to
For
run up,
taking
my lord.
photograph cannot establish it is my saloon lordship. It's taking photograph from outside my room lordship, that can be established. My phone number purpose is that my sister is married and sometimes she is not there at my home lordship. That is the only reason I have to given the phone of mine. So I am doing nothing lordship. That is the only reason lordship. And that they have also enclosed on Jawabandi, which belongs to me lordship, but it is my father's property, instead property, father gave me
Have
lordship.
you filed your written statement?
No lordship, me lordship instruction not enclosed lordship, yes, I filed it there lordship.
Huh?
Yes, lordship, huh?
Have you filed the written statement? Manu, achhe?
Yes, lordship.
You have filed the written statement. Written statement filed, madam.
Yes, I have already filed.
No, there.
No, no.
They've got to stay here.
Immediately, he has approached to this honorable court, my lord, to take a stay, my lord. The matter is stayed, my lord. And this is before, my lord, the district.
Ojai to Bongaigaon, it's pretty far off.
No, my lord, this is also, my lord, the court where the presence of the petitioner is not necessary, my lord.
Oh, no.
So lordship, he
My
is
lord, this
coming.
is the-
In
my
two
lord,
cases,
no,
he is coming regularly attending
No, no,
Bongaigaon. In maintenance
No,
case, he is coming. In divorce case, in
My
DT
lord,
case, he is
the
coming.
court is, my
So
lord, the
lordship, it is
district
very
and
convenient for him. The same time,
district
same
and
day.
session judge, my lord, where the court
Only
is, my
district
lord.
court.
Okay.
court is lying.
Do one thing. He will pay you, she will pay you 5,000 rupees. You go there.
Okay, my.
You pay 5,000 whenever you.
Lordship, how I can pay? I'm independent.
Your
No,
name is
my lord,
there.
she has,
No,
my
no,
lord,
lordship.
then, my
Lordship,
lord.
That is the subject,
No,
that is the subject for stay.
Lordship, no, lordship, I may be allowed to submit the trade license. I may be,
Not
so
necessary.
yesterday I got the, lordship, I've got the instruction.
necessary.
Yesterday,
My lord,
that-
he has
no, no,
You can't
no,
go.
no, lordship.
If you want to go,
No, lordship.
if
let
you
me-
want to go, he will pay you 4,000. If you
no,
doesn't
no,
want to
no,
go,
no,
he will
no, no,
pay.
I can, lordship, please
Okay.
listen. Lordship, yesterday I got the
Which
affidavit.
one do you want? Either of it.
Lordship, yesterday after getting the affidavit, I got the instruction and then they are saying that it is belongs to their sister only. And he,
Leave
only
the
our
matter
phone
up
number
to
is there.
vacation,
I will-
interim order. This court is however taking into account the affidavit, so additional affidavit so filed by the learned counsel appearing on, appearing on behalf of the respondent,
I may be allowed to give the reply, lordship. Give me permit, me, lordship.
appearing on behalf of the respondent is not inclined to extend the interim order.
30.
Yes, Mr. Oloskor. What is this?
This case involves custody of the child.
What are you challenging?
At page 34.
Huh?
The interim order is at page 34. It is passed by Judge Subordinate Dimasa Autonomous Council Court on the custody. The findings are at the bullet points. Second bullet points.
What are you challenging? With the above concern, the court of so and so hereby declared T.S. so and so resolved and no further discussion on the matter be made. This is under the customary court.
Yes, customary court.
Huh?
Customary court. Right. The marriage was solemnized under the.
So against the customary court, but he's a judge subordinate Dimahasa Autonomous Council.
Yes.
What about the other side? There's no appeal against that.
There is no appeal. There is no appeal against it. There is
This
no-
is done under what act?
uh, The court functions under the North Kachar Hills Autonomous District's Administration of Justice Rules, 1955, under the sixth schedule.
So as of now, there is no appeal lies district judge.
No appeal. There is no provision for it.
So we are to exercise 227. 227. Or what?
115.
227. Hello. Okay, list this matter again on, so none, what about the service?
So the respondent number one died as per the office,
Unserved notice,
as per office note, my lord, the respondent number one died.
then,
Her name may be struck off.
then,
And the other two respondents live in this same house, but no report has come or unserved.
service is not complete. Okay. It is seen that the service upon the respondent numbers 1, 2, and 3 is not complete. Comma. The petitioner is directed to effect service upon the said respondents by way of the stay routed through the registry
Dosti
of
may
the
not be
spot.
possible, ma'am. Dosti may not be possible.
Okay, yeah, not complete. Full stop. It has been submitted that the service by way of dusty is not possible. Considering the above, this court is not inclined to extend the interim order so passed accordingly. The
My lord,
interim order passed on 12/9/2023, whereby the order dated 8/6/2022 passed by the learned judge subordinate of Dimahasa Autonomous Council Court Haflong in title suit number 169/2021 was stayed is hereby vacated.
my lord, kindly appreciate the facts.
Next.
My husband, the petitioner husband has
help
died.
you.
One,
Custody is given to my in-laws.
Vacated, vacated. Next.
item 31.
Yes, Mr. Sen.
My lord, why is before your lordship, my lord, seeking transfer?
What about service?
Service, my lord, as per office note dated 13/5/25.
Take service by Dusty. It is seen that the service upon the respondents, sole respondent is not complete even after a passage of more than 1 year. So considering the above, this court directs the petitioner to effect service upon the respondent by way of Dusty routed through the registry of this court and file an affidavit of service on or before the next stage. List the matter again on 18th of July 2025. Interim order passed earlier shall continue till then.
32.
Transfer, anybody appearing, both sides?
Lordship may kindly peruse the office note dated 3/8/24, my lord. Steps has been taken, my lord.
Service complete. The service report
ma'am.
by register as well as usual process not yet received.
Yes, my lord.
Service
As
report
per-
by register as well as
Notice has been received by the
not
father.
yet received. Okay.
As per, my lord.
Why the Dusty you have not taken?
Yes, my lord, we have taken, my lord, and
Then?
we have also filed the Rusty affidavit, my lord.
Okay. Dusty affidavit filed.
Yes, my lord, on
Where?
17/7/4.
What are you challenging here? Transfer
Yes, my lord.
from?
From Principal Judge Nalbari, my lord,
Who?
Family Court Nalbari to Principal Judge Family Court Kamrup, my lord.
Why? So nearby.
Lordship, the petitioner, my lord, was a resident of Guwahati, my lord. The marriage was solemnized at Guwahati, my lord. And my lord, the registered marriage was also at before the Kamrup, my lord, marriage officer Kamrup Metro. After the marriage, my lord, they shifted from their matrimonial home to Adabari, my lord.
Who has received this as per your affidavit?
Dusty, my lord, has been received by the council, my lord, council appearing for the respondent at Nalbari, my lord. While handing over the interim order, my lord. And
But why did you give it to the council?
lordship, the respondent is continuously not appearing in the matters, my lord.
No, don't you know their house?
Lordship, he took the counsel for the petitioner, he himself took the petition to hand it over to the respondent, my lord.
No, you can't do that. That is not service.
On behalf of
It is seen that the service has been meted out, not upon the respondent, but to some other person.
for the counsel, appearing for the respondent.
But to where?
To the counsel for the respondent, appearing in
No,
the
where have you mentioned
lordship, it has
completed
not-
the listing? You have not mentioned how do you serve. And have not been, it is seen that the service upon the respondent by way of Dusty is not complete. And more particular, more, it is also seen from the affidavit so filed by the petitioner. By who has filed this?
lordship, I have filed this one. Because I went,
Affidavit so filed also does not show that the service have been effected upon the respondent. Accordingly, this court therefore rejects the affidavit of service so filed on 7/8/2024. So it is further seen that by an order dated 26/6/2024, there is a stay to the matrimonial D, to the proceedings being matrimonial D number 123/2024, pending before the learned Principal Judge Family Court at Nalbari, Kusto. Taking into account the above, this court directs the petitioner to effect service upon the respondent by way of Dusty, routed through the registry of this court, and file an affidavit of service on or before the next date. List the matter on 21st of July 2025. Interim order passed earlier shall continue till then. No, sir. একটু পেছো, মোক এটা কথা কওক। এইবোৰ ফাইলিং যে হৈছে, আপোনালোকে কেনেকে পাৰ্মিট কৰিছে এইবোৰ যে একো ফিল আপ নকৰাকে? How is it possible the name of the advocate এইবোৰ বাৰু নাই? সব কেছত এখন কাগজ এখন মাৰা থাকে নহয়, এইটো দিয়ে। Why there is no mention of the son, মানে এই যে সংগীতা দাসৰ ফোন নম্বৰ ইয়াত কিয় নাই? Is it required petitioner এইবোৰ ডিটেইলছ দিবলৈ? এনেকে হলে আপুনি এক। দুই নম্বৰ কথা, এইখন এফেক্টিভ এফিডেভিট নহয় নেকি? ক'ত আছে? লাগিব নি এফিডেভিট খনত ক'ব নালাগে নেকি ফোন নম্বৰ এইটো, হোৱাটছএপ নম্বৰ এইটো হয়, এইবোৰ লাগে নাই? So then how is this filing has been allowed? And why this person who has passed this deputy register, whoever it is doing it, why this person is not there? How can the deputy register, why the deputy register? How is it, whether it is actually filed by this person properly? নহলে এইখন কেনেকে pass হল মোক কওক? After the High Court rules have been amended, this is filed in 2023, maybe because of that, not 2023. না না ঠিক আছে, এখন আগতে হৈছে, কিন্তু এতিয়া যে এখন ফাইল হৈছে এফিডেভিট এনিৱেজ, কিন্তু আমাৰ নোটিফিকেশ্যনখন দিয়া নাছিল। The group lawyers who is foreign, they have been asked to do it. They have not given it. So it's a problem. The affidavit খনত এইবোৰ details দিব লাগে ন। Anyways, এখন হ'ল 2023, এখন notification amend 1 আছে। পুৰণা equity। আৰু এতিয়া হৈছে দেখিছে এইখনত বিশেষ নহয়।
Item 33.
What are you challenging?
I'm challenging the judgment and order passed by the Honorable Special Tribunal in the land grabbing case. Only that, why I'm challenging, while deciding the criminal civil liability, Honorable Court, Honorable Special Tribunal has not examined any witness. This is essential. Your Lordship.
Why the service is not complete?
Services not, though postal service.
It is seen that in spite of a period of more than, in spite of a period of 8 months, the service has not yet been effected upon the respondents. And there is a stay order operating.
Some of the respondents have received, here the respondent number 5, respondent number 3 and 8.
They have what?
Respondent, the notice unserved has returned for respondent number 5. And for respondent number 3 and 8, neither AD nor unserved notice have returned. There are as many as 8 numbers of respondents there.
Your case has been dismissed. Huh?
Dismissed.
The case has been dismissed by the trial court. So how can there be a stay?
Stay of the operation.
How can there be something which is dead, you are saying that don't die? No, I'm asking you, can it be possible? So it is seen that the service upon the respondents are not complete. First of the petitioners are directed to effect service by way of by taking fresh steps upon all the respondents by way of registered as well as usual within 7 days. This court further takes note of that by the order dated 38/2024, the judgment and order dated 23/7/2024 passed by the Court of the Additional District and Session Judge Kamrup as special tribunal in respect of special LG number, case number 1/2023 was stayed. However, it is relevant to take note of that by the impugned order dated 23/7/2024, the proceedings have been dismissed. Under such circumstances, the question of stay does not arise, for which the order of staying the impugned order dated 23/7/2024 stands vacated. Full stop. List the matter after completion of service.
34.
Service upon the respondents have been completed and by the order dated 8/1/25, there was a stay.
You went from Bongaigaon to Guwahati?
Yes, Lordship.
What do you do?
Lordship, I am a housewife.
Housewife? Transfer.
My lord, petition is silent, my lord, whether when marriage was held, when, my lord,
You know?
where they, my lord.
You know you are the husband?
My lord,
You know when is the marriage held?
one more submission is that, my lord, a case is pending before the district judge. She need not to appear regularly, my lord.
Necessary.
35.
11th of August, go and file your written statement before here, the principal judge. You want it here, na?
Yes.
Allow.
Always.
All right.
Yes, what is this? What order you asking for stay?
Lordship, we have instruction to withdraw the,
Huh?
we have instruction to withdraw the.
Mr. Name?
SPO.
ASJ Circular, the learned counsel for appearing on behalf of the petitioner submits that he has instructions to withdraw the instant case. Accordingly, the instant petition stands closed on withdrawal, the interim order passed on 2/8/2024 stands vacated. Full stop. Consequently, the petitioner is directed to appear before the court of the learned MACT Dhubri in MSC case number 197 of 2022 I on 14th of July 2025. Full stop. The registry shall also intimate the instant order to the learned court of the MACT Dhubri for further continuation of MAC case number 197 of 2022 I.
36.
Mr. Monto, what is
Against
the
the order, my lord, that is under order 41 rule 27, that was dismissed by the my lord, appellate court. So my annexure file of the document number 5, that is the petition that was filed long back by my predecessor, my lord, to my lord, bring the record regarding the acquisition of the land on one part of my original land.
So appeal was taken, what was the stage?
My lord, this is final hearing is not completed, my lord. Appeal.
Huh?
Final hearing is not completed, my lord. Appeal. But the record was called for, record has reached, my lord.
No, no, was the appeal taken up for hearing?
Not yet, my lord.
No, my lord, what happened, they filed a, they wanted a interlocutory application where they wanted to bring a letter they had written when the titles were started, trying to vindicate their, to the DC. Now, that letter was rightly disallowed by the appellate court because firstly, because.
No, Mr. Kimachaji, I'm only asking a simple question. Was it done at the stage of appeal hearing or was it done at any other stage?
No, not appeal hearing. My lord, prior to hearing was started, my that was filed.
It was done in the appellate proceeding.
Proceeding was there, but the appeal was not completed.
You are, who is the respondents here?
He is the government, my lord.
Okay, we dispose it of. Thereby reinstating the miscase to the file of the appellate court to decide the appeal and along with that to consider this application.
But when the record is not.
Huh?
The record, my lord, I seek to be produced before the court because, my lord, the record, these are only things they show.
No, Mr. Counsel. This is an application which could not have been taken into consideration by the appellant except at the time of hearing as to whether he requires this evidence for the purpose of delivering the judgment.
Yes.
That is the mandate of Ibrahimuddin. So we allow this, allow your petition, but only restore it to the file, thereby directing the first appellate court to decide this application along while hearing the appeal.
Yes.
And quote Union of India versus Ibrahimuddin.
Yes.
You look into the judgment,
Yes,
2012, 8 SEC 144. And then make the submission next time, disposed.
Well.
And you appear before, there's a stay.
There's a stay.
So you appear, disappear on 16th of July. It will dispose.
37. For all the respondents, the two respondents, state respondents.
Hello.
Must.
Election shoes, what has happened? Other side?
Lordship, I have served the trustee on 29/5/2025 at their
And
office.
then affected.
Affected, my lord. Paragraph 2 of my affidavit. My lord. It was received by one sales executive of AP Trade and Commerce. My lord.
Siddhan Das. Who is Siddhan Das? Received by?
My lord, received by Raghubir Kumawat.
Huh?
Raghubir Kumawat, sales executive.
Who?
My
There's
lord,
no seal, nothing. Who is he?
He
you
is the
mentioned?
sales executive of AP Trade and Commerce.
What is the next date?
Before the trial court.
Huh?
But it's in the month of July.
Taking into account the affidavits of service, list this matter again on affidavit of service, this court accepts the service upon the respondent numbers 1, 2, and 3 to be complete by way of Dusty. List this matter on 23rd of June 2025 for admission. Interim order passed earlier shall continue till then. But I was told, okay, that is another.
Motion item 10 as the last item.
Oh, yeah. Yes, what is this matter, Mr. B.K. Sen?
Your Lordship.
Mr. Sen, last item of the day. There's no time constraint. This is the last item of the day is only for 5 minutes. You have to complete it within 5 minutes or do any other day. So when the matter comes for motion, the council is not happy, it goes in the last. What are you challenging?
My lord, written statement against counter claim. I am the plaintiff in the suit, my lord.
You did not file.
I could not file.
How much is the delay?
There is, my lord, only thing is that, my lord, the date was posted after 90 days, my lord. And thereafter, my lord, on that particular day, my lord, we filed an application praying inter alia for allowing us, my lord, some more time to file written statement against counterclaim. That has been, my lord, turned down by the Lord.
Your written statement is ready.
It's not, my lord, because we need to take, my lord, obtain certain documents, my lord, which are material for the purpose of proving the plaintiff's case. That was, my lord, the.
If you are not ready as of now also,
After this.
I am asking you, is your written statement ready or not?
Yet. I'm, I'll be, it will be ready, my lord, within a period of, my lord, as your lordship, my lord.
When is the next day before the trial court? 27/6.
27/6.
Okay. We have it next week, this matter. Get your written statement ready by then. Is the matter on 13/6/2025.
Can file your lordship, may.
I will give, provided you have your written statement ready on 13/6. Then only. Otherwise, if I am to interfere with an order which has completed 90 days as on 25/2/2025 and till now, after 4 months, you have not completed this period of limit written statement, then I think it appears that the manner in which Mr. Sen also approaches the court.
Lordship is absolutely correct, my lord. There is no doubt.
Get your written statement ready by 13th, then only I'll consider. Promotion it will come on 13th. I am not saying until, leave the matter on 13th. I am just telling, when again the matter comes on 13th, I'll put that question, written statement ready or not. If it is not ready, then obviously, why should I interfere?
Lordship may also observe,
I
my lord,
am
on that,
not.
on the next day fixed by the learned court below, my lord.
You get your written statement ready. I'm not asking you to file it.
Right.
I'm asking you to make it ready.
Orders item 24.
Why have you not taken steps?
Item 24.
Steps were taken, but the whereabouts of the defendant could not be found. After that, we given a.
Is there stay? No, stay as a big do. None appears on behalf of the petitioner, full stop. Oh, in spite of the order of 23, shall intimate the inquiry about the Winston order. Okay, no steps have been taken. It is seen that in spite of the orders being passed earlier, no steps have been taken upon the respondent.
The steps already been taken.
When?
So this is the, by postal Talabana,
When?
uh, 7/6/2016.
Madam, are you not aware of what orders are being passed by this court from time to time? Considering the above, it seems that the petitioner is not interested in the proceedings for which I'll dismiss. Can't help it. You're not interested. It is seen that the petitioner has not filed any steps, not taken steps, in spite of the order passed on 23/5/2025. It appears that the petitioner is not interested in further proceeding with the instant proceedings.
Sir,
Considering the
kindly-
above,
Sir,
this
kindly
court directs the
time.
learned civil judge Morigaon to proceed with the proceedings of title suit number 6/2012. Full stop. The registry shall intimate the instant order.
25.
Yes, service not completed upon last number 121.
Yep.
Yes, why the matter has come today?
Your Lordship, on the request of Mr. S. Paul, I have been asked to take adjournment because one of his relative died. And
No, not on that. I'm only saying why the matter has come today. ये भूल क्या ऐसे? It seems that the office have not taken note of the order dated 9/5/2024. No, I have listed this matter is duly complete, leave the matter on 6/6. So it has been submitted by Ms. So-and-so, the matter be adjourned. So taking into account the above, there's a condonation application, madam,
yes, Your Lordship, by my knowledge, I've just been informed.
857 days. So taking, other side has not appeared, na? Okay, the learned counsel appearing on behalf of the applicant submits that some time may be granted. This the matter immediately on 16th of July.
Much obliged.
26.
Mr. Anybody appear on the matters? Everybody, you are paying for everybody?
Already, I have appeared on 1, 3, and 5. And rest of, today I have filed Ukala Sharma.
Okay.
I am appearing on behalf of all the respondents.
Okay, so here what he was asking is
About amendment,
of,
rejection of amendment of plan,
Madam.
changing the patta number and boundary.
this should be allowed. So that
I had filed a affidavit.
you are a pure civil lawyer.
Yes,
When you are a lawyer, civil lawyer never files affidavit out here in a 227 or 150.
okay.
Okay? Don't come up with that excuse. Affidavit.
Then let me fix.
It is something like filing an affidavit in a 482 proceedings. Tomorrow you may say, oh, in criminal appeals also I'll file affidavit.
No.
Now, do you want that?
No.
Then don't make this type of submissions and before this. Service being complete, leaves the matter, we'll finish it up next week. On 11th June 2025 for
Madam-
admission.
My lord, other than
Interim
11,
order passed earlier.
other than 11,
Okay, 13th.
please.
By
27.
Oh, sorry.
Yes, what is this?
The additional court fee has been, submitted, but it has
Huh?
not come up with the record.
See. Issue notice. Oh, I have admitted the appeal
Yes,
now.
madam, yes.
Records have come.
No, madam,
Call for the records. Records have come. No.
no, madam.
Service of the Iman, service not completed. Service not completed.
We have taken a step out.
Oh, you have not deposited the court fee.
deposit.
Mr. So-and-so, the learned council submits that the additional court fee of rupees
3183.
82.60 have been duly deposited today. Full stop.
Yesterday.
Huh?
Yesterday.
Yesterday. Full stop. It is further seen that the service is not complete upon some of the respondents.
No, all the respondents.
Huh?
All the respondents.
Not complete.
Not complete. As per the record.
No, no. On some of the respondents, service not completed in respect of respond number 1 to 8, 9A to 10A, 11 and 17. Yeah, so not complete.
Not complete.
Not complete.
They
So,
were done.
taking into account the above, list the matter again on when
The lots of them.
you take fresh steps, no.
Let us wait, madam. Let us wait, madam. We have taken the steps since. Let us wait, madam.
List the matter after completion of service. Because I have not given you a stay, that is why.
28.
I will stay to give, list the matter again on taking into account that the steps are not, service is not complete. List the matter again on 18th of August.
But the court fee which we have submitted, madam, that will come out of the record.
I've mentioned that. Yes, what is this?
28.
This is a FAO, my lord, that was filed by the appellants, my lord, challenging an order allowing the appointment of receiver under order 40.
Oh.
The appeal was already admitted, man.
Huh?
Appeal was already admitted.
Appeal admitted.
I'm for the sole respondent. Appeal admitted,
You are for
sole respondent.
sole respondent. Okay. Why the matter has been listed? Pursuant to an order.
My lord, because of service, my lord.
Stay.
Stay is also there, but stay was not granted,
Issue notice. So I have admitted it.
my lord.
Oh, I don't admit orders.
Partition suit, my lord, they have been accumulating money, collecting money from the tenants at the rate of rupees 1,60,000, but without giving any money to the other co-sharers,
Okay. Then, I have admitted the appeal.
my lord.
Appeal. Full stop. List this appeal along with the application on वो नान ने लिखी वो देखा कौन ये साइट ऑफ कैप्शन on we can dispose it of in short order na on 23rd June 2025 at 2 p.m.
Deeply obliged.
Item 26, madam.
Huh?
Interim is there, madam. Item 26, madam.
Oh, interim order passed earlier shall continue till then. Next it. I fixed it next week, na?